Lordship may kindly have the order of 22nd of June 23.
Yes.
Lordship. Okay, come.
Yes.
Lord, at paragraph 5 of that order,
Hmm.
Lordship has noted the issue. Number is issue of vulnerable witness deposition center required for POCSO courts. Second is child friendly court, and third is investigation of POCSO offences. Then my lord has directed us to file an affidavit and certain indicating certain information at paragraph 7. In response to that, my lord, we have filed the affidavit on behalf of the DGP. Possibly it is, we have also done the filing now.
Acha.
On H6.
On 8/6.
It's 309.
Page is
309.
309.
Lordship. One is Lordship, another affidavit is 206. Page 206 is also there.
206.
206 and other one is two affidavits we have filed. Other is 309. Oh, page 209. Page 209. Possibly page numbers has some difficulty. Lordship, may kindly see the affidavit filed by Nitul Gogoi on 8/6.
H6 is part of.
One affidavit is filed on 27
No, my lord,
July 22.
both the affidavits are filed on 8/6 yesterday.
Acha.
H6,
8/6,
87.
Sorry, 8/7.
Huh.
Yesterday. 8/7. Filed by Nitul Gogoi. No? The deponent is Nitul Gogoi.
There is only one affidavit on H7.
It's only one affidavit is there.
8/7.
So H7, 309.
It should be very-
There is only one affidavit, H7. Other is-
Sorry. But on file on 2/8 yesterday.
Oh, that is
2/8.
not done.
That is not.
Yes, sir.
It's not very-
You have an extra copy?
This copy has been served upon my friend. I can give.
Acha, it's okay. You take your copy. We will get Mr. Das's copy.
Lordship,
Huh.
no, my copy, I have delayed.
It's good you have become high tech. So, very welcome.
We are trying, my lord.
We have compelled them.
Lordship, the affidavit filed by Mr. Nitul Gogoi.
Hmm.
Kindly, my lord, come to para 2. These are the queries, my lord. The Honorable Court, by order dated 22/6/2023, inter alia directed the state respondents to file affidavit addressing several issues, queries, and out of which some are related to the respondent number 4, that is the DGP. And those are whether any standard operating procedure has been finalized for investigating officers investigating the cases registered under the POCSO Act. Second is whether the POCSO kits required for investigation are made available within the reach of all police stations, and other specific requirements have been provided for. Next is to inform about the status of special POCSO police officers. Then whether any steps have been initiated for training to the special POCSO police officers. Then whether there is any plan in the state in place of which officers who are entrusted investigation of POCSO matters are not taken out of investigation and assigned other duties. But in response, we have from paragraph 3, we have stated, as regard the first query regarding the standard operating procedure of the officers investigating the cases registered under the POCSO Act, the deponent begs to state that the one standard operating procedure in both English and Assamese language has been circulated to all concerned for the investigating officers of POCSO cases by memo number 25/9/2017. That SOP has been annexed at Annexure 1. Lordship will find at Annexure 1. Then, my lord, as regard the second query relating to making available of POXO kits within the reach of all police stations, the deponent states that no POXO kits and other specific requirements are made available within the reach of police stations. However, SAEC, sexual assault evidence collection kits have been distributed to all districts. That next, my lord, as regard the query regarding status of special POXO police officers, the deponent states that there is no provision of special POXO police in the state, but the second officer in charge of all police stations have been designated as child welfare protection officers for dealing with child in need and of care and protection and child in conflict with law. Trainings and programs have been regularly conducted by CID on women's safety during the period 2021-22 that we have stated. As regard the next query, my lord.
You see, here you'll have to also take care of another aspect.
Malak.
That aspect also there is another aspect which I flagged earlier.
Got it.
You see, what is happening is that under the let us say that when the child abuse takes place, some obscene photographs are taken or some electronic evidence is required. So what has happened in that IT Act, you have the provisions of Section 81, which says that the investigation shall be done by the inspector. Whereas in the state, the inspectors are not available in the Thana level.
Okay.
So after flagging of that issue, the police authorities, they have come out with a notification which says that invariably whenever any case relates to IT is being investigated, then the investigation shall be handed over to the inspector. So that circular has come out.
Gotcha.
So in these cases also, when you'll have to flag it that to the investigating officers or child welfare police officers, that whenever in any case they have to deal with electronic evidence, then perhaps that part has to be investigated by the inspector. Now, there's another aspect which you'll have to take a decision. When it's a opposite composite where there's also a violation of, wherever there's an involvement of IT Act. And then there's also POXO. Then possibly you can't divide the investigation into two. Then you'll have to take a call that who will take up the investigation then in such cases where you also have to deal with IT
and POXO both together.
and together. So can you take a note of that also?
Lordship, I'll definitely both the things.
Just a moment.
I'll take instruction.
Just a Yes,
But kindly come to the next paragraph,
yes.
paragraph 6.
Hmm.
Well, a detailed handbook has been, they have published, well, as regard the query relating to the training provided to the special police officers investigating the POCSO Act cases. The department begs to state that a detailed handbook for investigation of crimes against women and children for guidance of all investigating officers was prepared in 2022. Also, a detailed circular dated 12/7/2023 by memo number so and so has been issued to all SPs describing the method of they have been issued to all SPs describing the method of dealing with the abused children and children in conflict with law. Altogether, 3 numbers of online training and 7 numbers of offline training have been conducted. Total 290 number of officers, inspectors, sub-inspectors have been trained to take up the investigation of POCSO cases. That handbook,
Here, I have seen that.
Logic.
You see, I have a
Logic.
query here.
logic,
It starts from 215. I have a query here.
logic.
Now, say for example,
Malad.
the handbook of investigation of the CBI. It has a statutory backing and there are judgments of the Supreme Court which has sanctified
Logic.
the handbook of the CBI to be what you call an approved handbook by which investigation has to be carried out. Now again, there is a problem. If you sit in any trial of CBI, then you find when there is a sanctity given to a handbook, then the cross-examination of the witness would be that in the handbook this is prescribed and you have not done. So it leads to a failure of investigation. You get it?
Correct.
The CBI is now strong enough to handle that because now in the cross-examination you don't get those loopholes where they say that it has not been completely followed or the preliminary investigation, the manner of final investigation, the regular investigation being done is under the act because it's now ingrained within their system and they scrupulously follow it.
Correct.
But in the state of Assam, to have an handbook and then give a handle to the defense lawyers to
cross-examine that this is not
present the witness on that point. So I think you'll have to give a disclaimer that it is not till you perfect your system. This will not be
either a statutory breaking or to have a disclaimer that this is not so that to protect ourselves from the defense process.
that's what I think.
Logic.
Yes,
Logic.
come to paragraph 4.
Manoj.
You have stated the facts only,
Yes, Malad.
but how you propose, what are the reasons that you are not having it? No explanation.
Malad, POCSO kits are not available, but the sexual assault evidence
No,
collection
understand.
kit.
That is a statement of fact.
Correct.
But this PIL is
Why?
to improve the system.
Logic.
The paragraph 4 is not reflecting anything on your part that this is what we propose. This is how we'll do.
Logic.
These facts is
These
that
are
you need to
correct.
give an explanation.
correct.
We are not saying explanation, but let's see. It
Either-
is not there here now, but we are proposing this
Logic.
and by within this time we'll do
Logic.
this. That
Why-
we think it's required.
Why it is not available, why it is not provided.
Yes.
Logic.
That is very vital.
Correct.
We are not so much interested on facts, rather we are interested on improving the system.
Correct. Logic.
You take note of it.
Yes, Malad, we have.
I think Mr. Das, you also go through and respond.
Yes. We also need one aspect to be considered. You see, in cases of sexual assault on child, or molestation, whatever be.
Lot.
You have stated that the second officer is now the child protection
Yes.
officer.
Yes, my lord.
But what is the system you have created whereby the children who are the victims, they get the benefit of counseling? Because you see, what happens is that, let us take an example that the child abuse has taken place within the close members of the family.
Correct.
Now, this child is always under the influence of the family members.
Got you.
So what happens is that if they are not counseled, a child will not know how to face the court as a witness.
Correct.
So therefore, there should be a counseling by virtue of which these children should be made aware of the court procedures. Not actually court procedures, they will not understand, but to how to give evidence in the court. At least that amount of what you call how they say,
Mechanism has
the backup system whereby these children are given some insight of how to appear in court, how to depose as a witness, what is required of them to depose. It's not a sort of tutoring, but it's a sort of counseling.
So that's
You're not saying that the witnesses should be tutored
with a free mind, she can at least
with a
tell
free
what
mind,
is there.
because that is why we have those issues of child-friendly courts.
Lordship.
And those, so how do you propose to integrate the system of child counseling along with the concept of child-friendly courts?
Lord,
And then,
but-
because as my brother has rightly said, we are more interested in improvement of the system rather than knowing the facts.
correct. Under the to my knowledge, under the Women and Child Development Department, the Directorate of Women and Child, the child protection homes are there. In fact, whenever a child or the minor girl has some difficulty, the case is registered. There is a system of mechanism. We'll come up with the details.
Also just so we understand that this is may not be the role of the police, but how will you coordinate? Is
Yes,
there
yes.
any procedure?
Yes, yes.
And
The
counseling will be part of
homes
the
are-
social welfare department. They are having counseling, counselors and all.
Yes, yes,
But
counselors.
how
they have.
police is doing their part so that it can be forwarded further, child.
Whenever somebody is found that she is
Because
having that problem,
police's role in
Lodge.
case of a POCSO will not end arresting the person or filing a search sheet or
Yes, yes.
investigation.
correct,
That role will definitely come.
correct.
Because how you are integrating the system, the police is arresting, the child is under what you call tremendous pressure, and then there is a counseling simultaneously going on, empowering the child to be a good witness, and in the meantime follow up by the child protection officers to see that these children are not under constant threat or pressure,
Correct.
and so that they can depose freely in the court. So there should be a seamless integration in the system
Lodge.
whereby one is supportive of the other, and then each one does his part.
Lodge.
So we also want to understand that aspect.
Yes, yes. Lord.
If,
Lodge,
if you have experts in the field who are doing this work,
Lodge.
they can also come and address us so that
But
we understand how they are
Yes, yes,
integrating the system.
Lodge, lodge. Well, children homes are there. Children homes are there whenever a girl child or a male child is in conflict with law. They police after taking that child used to keep the child in the children home a lot. In children home a lot, we have all the facilities and the counselors and all are there. But that integration definitely detail will place before your lordship. Lord. And in the some indication is there in the handbook also.
Let us respond to it. You also get some other to respond to your affidavit.
Mr. Das, this is not an adversarial litigation. So what we will expect from you is, Mr. Senior Government Advocate also,
Lordship.
that they have filed an affidavit. These affidavits are being filed by some officers. They may not understand also from the language of paragraphs. Court says that something has been asked, so this is our answer.
No.
this litigation is not for that.
Yes,
So you have some suggestions from
true, my lord.
from your side. You are at liberty to consult with some counselors or expert in this regard.
Yes, my lord.
And you also come with
Lordship, lordship,
your stand
lordship.
and file a, will not say it's affidavit, and you can file a note
Report by
also or
the-
report
yes.
whatsoever,
Yes.
so that we can proceed further.
Lordship.
My lord, one thing I'd like to just place before you, the child-friendly police officer as conceived in the act, to my understanding, it's totally a separate cadre, as has been, as I have understood, that person will be only for that purpose.
No, that is
Now,
why.
this is a stopgap arrangement.
Mr. Das, that is why we asked for an affidavit. And
True, madam.
now they have said that there are 290 police officers who have been trained for this purpose. And the understanding which we are, the inputs we are getting from the police authorities, because we are also dealing it on the administrative side, under the committee.
True.
So what we are, what the inputs we are getting, which finds support in the affidavit file here, is that these 290 officers, by and large, will be attached to this child, what do you call the child crime.
POXO,
POXO, offences. But you see, police officers in course of their duty have to be transferred. We can't direct that the police officers once appointed will never be changed. So therefore, what we have understood is that the state police is also undertaking a process of continuous education
Increase.
program, so that batch by batch the officers are trained. And therefore, supposing there's a necessity to transfer, say, let us say out of 90 people they want to transfer. So this replacement which they will give will consist of officers who are well trained in this aspect.
That is what, yes, as lordship is absolutely correct. My lord. What I am saying is that, I am not saying that you keep that person in that particular thana. You rotate those persons, transfer those persons, but there has to be one person or one officer who is trained in this subject to deal in a particular police station, my lord. Perhaps they have to increase the number by inclusion of further more training, but that aspect has to be, because this is a very sensitive issue, my lord.
Give your,
In
your-
fact,
You give your suggestion.
in
give your
fact,
suggestions, we'll take it.
in fact, Lord, there is another PIL pending before the honorable court, where the issue is relating to the separation of investigation wing and the law and order wing. There, my lord, we have in fact placed a notification that the government has already notified that the investigation and law and order, maintenance of law and order will be different. And in fact, batch by batch training only for the purpose of investigation only, that has been done. To an extent, it has been done. Lord, in fact, what lordship has just expressed, my lord, that the persons who are just 290 people for investigation of specially POXO cases or cases relating to child. So that investigation they will be from the investigation wing, and they will even if it is transferred, that has to be taken care of. Will definitely, because my lord, the mechanism has started now. It has to be developed.
So you
that
give
is
this,
That is
facts on an affidavit.
Correct, my lord, correct. Because things have moved, my lord.
Okay,
We are
not
ready.
saying that
We are ready, my
not-
lord. We are ready to improve. Ultimately, from suggestions from all sides, my lord, then.
Because we are being compelled to take this matter in the administrative side also.
Correct.
And we are also compelled to take up this issue in the PIL, because what is happening is that otherwise, if we don't take it on the judicial side, then the system which would be ideal under the POXO Act
Right.
has not been put in place till now.
Got it.
So therefore, we have been compelled to take up on the judicial side, so as to ensure that the system is upgraded, where the court does not have to monitor the basics of the infrastructure of the POXO Act, where
Logic.
you have this police officers, trained police officers, the trained paraphernalia like the
Correct.
welfare, child welfare department, counselors. They are all in place, and they all do their assigned work, so that the court doesn't have to monitor now. So that is what the intention is.
Correct. But in this case, another affidavit we have filed from the judicial department, my lord. Lordship, I just in between, my lord, I pray that I may be allowed to call for those affidavits, my lord, hard copies. Lord, in
You
the
take this file,
No, no,
You-
I have the copy. Just I pray for allowing me to call for those affidavits.
Oh, I said to call for.
Call for. Yesterday we filed.
Okay.
Give us the.
Well, from the, because as regard the VWDC and
Just a minute, just. No meeting of China, Secretary of the Government.
second judicial. Judicial copy, তারপর But another, just logic.
Paragraph 2. It is separating of various steps of time to time, right? Direction was.
Just affidavit file, yes, that is true.
Okay, and we see, past. And no, please take no reply to that this. When that we affidavit by.
তার মানে order to PL 60 তে উলালে মোর 60 তে পাইছি।
All positions in second, whether they have done, not done, what is their problem, why they have not been able to comply with, please something.
We are just thinking aloud.
Right.
If you come to the affidavit which has been filed by the Secretary, Women and Child Development Department,
Earlier.
no, 22, the 8 June 23,
Logic,
8 June 23. Kindly have that in your hand.
logic. Logic. Yes, ma'am.
See page 2 of that affidavit, 310, running
Logic.
page. Second page of the
Second
affidavit.
page, logic. Logic.
Now, read paragraph 2 first.
Various steps from time to time in compliance with the direction given by the Honorable Supreme Court of India in case of Sampurna Behura reported in so and records regarding steps taken are have been taken into record. Logic.
Now, one,
Logic.
no reply at this stage.
Hmm.
Number 2,
Logic. In fact,
next page.
logic.
See, if nothing
Plus,
is,
in fact, what I find, I called the officers to my office twice. But in fact, this SCPCR and CPCR, they said that this is a separate authority. This will be this will be given by them. Because the State Child Protection Commission, I also again called them. They were supposed to give me report. Actually, what I find, under paragraph 95, several directions are given. At the administrative, the administrative functioning, one department is not looking after all the, they are
It
not.
is fine. That is
not-
not an issue for us.
Logic.
You may explain that this is what it is being proceeded, this department
Correct.
will involve. in.
Correct.
Can this be a reply in a high court that can
No.
be filed by a secretary?
No, my lord.
The explanation you have given, can't that be incorporated in that paragraph?
In fact, no, my lord.
Isn't it?
No.
because you see, if it is non-compliance, that is why we have to take it up in judicial side.
Correct.
Now, even
Correct.
in the judicial side, if the government says no, because the government can't say that it does not have the paraphernalia to what you call comply with the directions of Sampurna Behura.
No. That is, in fact, at that stage, this particular secretary, he said that I don't have the information. That is what, otherwise, non-compliance is not at all.
Let him say that this
Correct.
is the
Correct.
department relating to so and so,
Correct.
not to this.
Correct.
Cannot,
No.
this can be, no reply at this stage. Why?
No, this has happened, logic,
Because you see, there is another aspect to it.
we will take care of.
No,
this.
there's another aspect to it. Number one, supposing the government does not have the paraphernalia to comply with the directions stated in this first
Hmm.
action taken,
Logic.
correct? Then he will at least write to the authorities and then say that now we have initiated the action by writing to the authorities to provide us with this or that. And that,
Now that we have started the initiative by this way, that way. no.
Correct.
they'll have to initiate some action
Logic.
and then tell us that we have initiated the action. Because if because the directions contained in Sampurna Vyavhara is a continuous mandamus.
It's a continuous mandamus, logic.
So the only thing which is required is for us to replicate that continuous mandamus in our order and then proceed in contempt.
But I'll definitely, I'll take care of this, not, it will not happen, it will not happen. I'll take care of and we will file an updated. FAR.
So Mr. Das, you have to go through it and then tell us.
Yes, my lord. Look,
Well,
there is another
Raj.
issue which is concerned in my PIL, that is PIL Sumoto. My lord, with regard to this child friendly code, my lord, now the government is coming up with this VWDC. My lord, VWDC came later because initially it is child friendly code. Child friendly code we have in Kamrup Metro, my lord, it's totally a different concept. But what this honorable court conceived, pending Millard permanent child friendly court in its Millard court, this honorable court conceived that pending finalization or pending coming up of the permanent structure, you just build some stopgap.
No, there is a practical difficulty which we are facing. This came to us on the administrative side.
My lord.
Now you see what has happened is that the infrastructure that is required to build a temporary structure is same and equal to the amount which is being spent for the permanent structure. Now, if let us say for an example, to build a particular room of that standard and that requirements which we are having, if you build a temporary structure, let us say it costs 4 lakh rupees. For permanent structure also it is the same cost. Therefore, what is the fun of giving a direction to the state government to make an expenditure, which we know that will be broken in 6 months? So therefore, you see, there are something which are which appears to be very innocuous when you are saying that make a temporary structure. But the cost of temporary structure is same as
In fact, it was processed, no? It was processed and in fact, fund was also there, it was processed, but
because
Well,
this is something which I question. That why if the expenditures are same, we should permit the government to make an unnecessary expenditure, knowing fully well that it will be demolished. That is one part. The second part is the great difficulties. Say, for example, the courts in Guwahati. We don't have space for this vulnerable witness deposition center. Let us take an example, random. Silchar, for example. Silchar, one part of the courts are functioning from the rented houses. Now you see, vulnerable disposition center. Let us say that today, while you are going out of the courtroom, you find a heinous crime being committed in your presence. Now it is not necessary that only a child would be a vulnerable or a woman would be a vulnerable witness. You have seen a crime which is politically connected. So it is quite possible that today you also become a vulnerable witness.
True, my lord.
Correct. Now, what is happening is that inside the court structure, we have the security people and everyone, and therefore we can have it. Supposing it is in the district court center, what we can do is that there are 3 gates. We can close one gate and make one access made specially for that vulnerable witnesses to come in, and they are protected. But if you have a vulnerable disposition center which is in a rented premises, now everybody can monitor who is going into that room, who is that vulnerable witness. Identity is exposed before you ever enter that room. Your identity as a vulnerable witness is exposed.
security.
So these are few practical difficulties which we are facing when actual field decision is required to be taken for protection of vulnerable witnesses. How do we ensure it? And the police will not keep a guard. The state government will not have the capacity to have the guards made in each and every vulnerable witness center. So you see, these are few teething problems which we are facing, for which we have no answer at all at present. That is why we need your assistance in telling us how this can be taken care of and how it can be implemented. The one issue you flagged, I have already said, what is the difficulty? Because the child, there's another aspect which you must understand. Number one, the funds of creating this vulnerable witness deposition center and these child-friendly courts, they are routed through 2 different government machineries in the government of India, and funds are given to this by the child, women and child development ministry. Now, they give a one-time funding. They don't give funding for creation of a temporary structure and then for a permanent structure. So therefore, 90% is a contribution from them, 10% is the state government contribution. Now, if you issue a direction to the state government to do it, now what happens to the funds for the final construction which has to be come up? These are issues which we, at present, we don't
One-
have an answer. You give us suggestions in form of a note also, not
Yes.
required that you
I-
give a
I'll come up.
affidavit.
Malad, in the,
The question, accept, but that question that I'm having is that. It's fine, Milord, there is some difficulty in coming up with this temporary VWDC, Milord. Or practically, it's not feasible at this moment because of the various issues. Then the ultimate solution is either permanent child-friendly court or permanent VWDC, Milord. Only question I'm having is that what will happen in the meantime, Milord? That was the thrust of the court in the earlier proceedings that I appeared. What will happen in the meantime? If a child witness, a child victim comes, how to deal with that child victim in the meantime? How to give him an atmosphere conducive to his mental trauma? That has to be looked into, and for that purpose only, this honorable court in the earlier round of litigations tried to get up a. It may not be temporary VWDC, we will not name it, but there has to be some accommodation in the courtroom, separate, having a monitor and a camera, or if possible, a separate entry, so that some courts, it's already there.
That's why you're saying, I'm giving you an example. Let us say district court in Kamrup. You give a suggestion how to implement that.
In Kamrup, Milord, we have a
No, I'm just
Child-
telling,
yes,
it's
yes.
just an example.
case by
supposing-
case, Lordship is saying.
Supposing you want to have a establishment created, how would you go about it? Where is the space?
Some deliberation is there in this regard, Milord. I'll just go through the previous affidavits and I'll come up,
Yes.
Milord. Because 16 or 17.
Because
Yeah,
you see,
in
there's
fact,
already
in-
there. You
in
see,
fact,
there-
17
there's only one
POCSO courts
answer.
are functioning.
In places where they don't have the infrastructure, is to go vertical.
Correct.
Yes,
Correct. Now, even for that, we'll have to disrupt a court activity. Let us say in Guwahati, we have temporary structure in the special judge Assam. If you want to go vertical, we'll have to disturb that court and
For
then
the
create
time
a infrastructure building there.
Lord, we only endeavor that out of the 33 courts, maximum we can cover.
Hmm.
17 we have already covered as per their.
Yes,
Lord,
yes.
Correct,
affidavit.
that is there.
Yes,
that is
Remaining
in
few
place.
are there. If some deliberation from our side, if we cover, Milord, 10 of
You
them,
can have those codes where it
Yes.
is still not there. You can have through the registry,
yes.
talk with the respected.
In fact, they have come up that where the space is available, but room is
Yes,
not
sir.
there.
Room to আছে something with so that sign entry to the election if it comes then it's minimum if not
তো রুমি
that we can
তোমাকে 3 নম্বর করে কথা ভালো লাগছে পিএসও ফেস কেটে বন্ধ করে দেওয়া সবাই খবর দিয়েছে
Mr. Das, you are also in that bench infrastructure.
Yes, Milord.
There also you raised this issue. I'm there in this bench, I
Yes,
think.
Milord. Yes,
So this issue, because this will relate to basically to the infrastructure.
yes.
That where these are not happening and why not happening, if we can pass some judicial order to
Malad,
bring to the notice of that court
My-
also in reference to this.
Lordship,
in the affidavit of the judicial department, Malad, we have given the status report of VWDC at different stages as on 18/7. Malad.
Hmm.
If Lordship may kindly have a look. Malad, BWDC, already in some construction, some in some districts it is available. Construction have been completed in some, and 80%, 90%, some works are already completed in some of them. This status we have given, in fact, in respect of all 33 districts.
Now, can we ask the PWD to tell us that, you see, for example, 16, work in process 70% completed.
Yes,
Target is 27/7, that is expired.
this is 18/7, as on 18/7.
No, I understand,
Lodge.
but we can get the updated status. We
Yes,
don't need
yes.
an affidavit for that.
Yes, I'll get that. I'll get that. Soraide also, they said that target date is 31/7. I'll get that.
From this chart, it's revealed that
Means,
Lordship, kindly for a moment, serial number 21, serial
Yes.
serial number 29. Those Lordship may kindly take care of.
Okay.
What is AA? Is AA awaited means
Administrative approval,
administrative approval from the government,
government, for fund,
so from the government.
for fund.
Okay.
Lodge.
So, on administrative side, we can take up this 20, serial number 21.
21. And 29 also.
No, 29, if we have approved on 25/5,
Lodge.
administrative approval is
Lodge.
from the PWD.
Lordship, I'll take care. Lordship.
Then this, let us come one by one. The
Lodge.
serial number 1, construction work completed.
One complete.
Uh,
Lordship, I'll get why
this-
it is not functioning. I'll get the instruction.
uh,
Borpeta is functioning.
3 is estimate prepared being submitted soon.
Vishwanath, they have
You-
no place. It is now prepared.
One
Administrative-
work in progress,
Lodge.
completed 90%. Work will be allotted and completed on 31/8.
Lodge.
Work allotted but not commenced is to initiate termination of contract.
Dhubri, they said there is no place. That is why it is proposed on rented.
Because here also, in this Dhubri, I remember that the place which has been chosen is also not, what do you call it, it's not otherwise a secure place.
Dhubri possibly is a congested place because for construction of the tower, high frequency tower, they
No,
were-
whatever be.
they were not in a position to give us space.
So therefore, this was something we had to discuss, and then it was approved
Logic,
because
logic,
it's a consideration of
logic. Dibrugarh is available. Dima Hasao, it is yet to be completed.
and it is at a distance from the court.
Dhubri,
Dhubri, it is at some distance from the court. So whenever this witness deposition center to be there and have the links made and then video conferencing of that deposition taken.
practically purpose will not be.
No, I don't know, but that is the reason when I said that
Logic.
statement that security. We go through it, Mr. Das.
yes, my lord.
From the registry also, you can take the updated status because our registrar administration is monitoring it.
Yes, ma'am. I'll get the status. ma'am.
Logic.
And then tell us, we don't need an affidavit
No,
on
yes,
that, just
Look,
a working
I'll
report.
instruction, yes, my lord. A
Huh.
report.
We can work on it then. So how much time you need for this?
But my friend is saying some council is coming from outside. If it can be taken up on 24th of August.
You ready? 24th August. Okay.
Logic. As regard the appointment
You
of-
also have your instruction,
I'll-
updated instruction regarding this.
on this. As regard the POXO courts and the appointment of PP in POXO courts, we have stated in paragraph 4 and of the affidavit. Paragraph 3, 4 and
this
7 also, as regard the fund and all, lordship will.
Just for your information, your chief engineer PWD is aware of the deliberations in the meetings. He was present.
Hmm.
So insofar as this activity is concerned, this chart, I think you will get the updated information from him because we have asked him to monitor it.
Lordship.
And whichever are there in this 70%, 90% category,
Hmm.
we have asked the PWD
Excellent.
to expedite this and to complete it. And he had assured that the completion will be made in this wherever the progresses are 70% and above.
Lordship. Lordship. And I'll take the.
Chief engineer would know of it
Lordship.
because he was there in the meeting.
Lordship.
My friend wants to make some submission.
Yes.
But the affidavits they have filed, they have served a copy upon us. In the affidavits, if I may submit, they have stated that 17 special courts have been functioning as on date. If I may bring it to the notice of this honorable court, that centrally sponsored scheme, there was a scheme in the year 2019. According to that, 27 exclusive POXO courts were earmarked for this state of Assam. So that regarding that, there is no statement in their affidavit. And more so in their affidavit, they have also submitted the SOP. However, a reading of the SOP seems that it just mirrors the POXO acts. Rather, there ought to have been some deliberation to state what are the role of the police officers and how everything is to be gone about in the system, rather than just imitating the POXO act.
No. So for that, I think they have given the handbook which says how it has to be done.
They have, Your Lordship.
They have given this this handbook of the
Yes.
of the investigation handbook for investigation
Yes. Yes.
officers of crime against women and children.
Yes.
So you'll have to find if this is insufficient.
We will file some additions and some suggestions with regard to
Yes,
that.
yes, you give the suggestions are welcome.
Their suggestions are always.
Yes, yes.
Because more so regarding the state
You
commission
bring
for
to notice that 27 courts and what happened.
very well, Your Lordship.
You bring to that
Yes,
also
yes.
and have a talk with him. He will.
Yes,
also
yes.
have-
Very well.
Those inputs are very
yes.
fruitful.
Yes.
Because I can, so that I can, because otherwise, whatever information they gives, that is my limit.
Very well, Your Lordship will assist in that.
Yeah, there's one more aspect to it.
Hello.
This insofar as child abuse is concerned in form of child pornography. What is the police envisage how to go about what you call, to check this child pornography in the internet insofar as the state of Assam is concerned?
We need to have it already.
Basis of ইয়াতে আমার এক কোন আছে না কইছে কইছে তো আমাদের কইছে লাগবে না
Actually, generally, they will leave this kind of block. That you cannot support VPN. By using VPN, you can access it. Otherwise, if you internet, somebody wants to access it on that's a deciding law. We cannot obtain it. Already.
Okay, my brother is saying that it is being
It is
separately-
already done by
separately
the Home
being-
Ministry separately blocking all those sites and all.
Otherwise, the offenses relating where internet, Lordship has already IT info offenses are there. That Lordship has indicated, we have already taken note of. I'll also take up that. I'll take up. Okay.
আপনার কইছিল লাস্ট টাইম আপনি কি হইছে এটা ফাইল আমি হ্যান্ডেল করব নোৱাৰিম আমি রিপিটিশন তো বেলেগ করব এফিডেভিট তো বেলেগ করব মানে কি হইছে সব এক লোক টাইমে
Infrastructure in Punjab
কি কৈছে আৰু এইবিলাক পৰা নিৰ্ভৰ কৰে।
এটা judicial order করে দিবেন নাকি যদি order একটা করে দিবেন section of ওই যে submit করে দিবেন তারপরে
নর্মাল টাইপ টু নর্মাল লাইফ
Paper
ঠিক আছে
My lord, if I may submit, since the lordship is fixing at 8/24, my learned friend may also be asked to take instructions regarding the formation of the juvenile justice rules and the rules and duties for functioning of state commission. for
juvenile justice board
Rules,
rules
your lordship. Those were also to be simultaneously formed in terms of the Sampurna Behera case.
because when you are referring to rules, I find that there is a Assam Juvenile Justice Rules 1998. Is there an amendment required to that?
The case with the PIL which was filed, your lordship, that was decided thereafter, so certain amendments are required in that. As well as the rules pertaining to the State Commission for Protection of Child Rights. How far they have been complied with, because to our knowledge, to our instructions, all the posts are not.
They have
filled up.
replied at paragraph 3. State level child protection. There are 106 registered child care institutions. Are you in receipt of this affidavit?
Yes. Only 8-6. 8-6.
Paragraph number, your lordship. Six.
That,
Serial number
that
3.
8/7/2023 filed by the secretary.
Lordship.
Yes, your lordship.
So you go through it, respond it, that
Very-
deals with the judgment. So you say that these are not being done, this is required, this
Very
is the
well.
mandate of the judgment.
Very
You
well.
respond to us.
Lordship.
It's better to give the copies in exchange the copies in advance. So that you can have, either side can already have the instruction.
Correct.
Hmm. Whatever you want to file a little bit early
Early.
Very
so
well.
that they can also have their feedback.
Madam. We served them copy, but only yesterday.
Correct. So try to do that a little bit
Little.
earlier so that they can respond.
Lordship.
That is what you call this Bachpan Bachao Andolan is by you.
Yes, your lordship.
You say but Mr. N. Chaudhary, counsel for the petitioner, in PIL 60 of 2019, also heard Mr. D. Nath, Leonard, additional senior government advocate appearing for the state of Assam. CGC will be there, Mr. Arkady Chaudhary. He's not. No present call for the Union of India. Next para. At the outset, the court is inclined to direct the registry through the AOJ read appeal section. Appeal section only. Read appeal section to bifurcate the records of this PIL into 3 parts. containing, first containing the order sheet, second containing the main rate petition, and the third containing the affidavits exchanged in the matter. Next para. The learned counsel for the petitioner has submitted that although the state government has notified the juvenile justice within bracket Assam, bracket close rules 1989, but consequent upon the judgment of the Supreme Court of India in the case of Sampurna Behura versus Union of India, 2018 4 SCC 433, certain amendments would be required to the said rules. Full stop. The learned senior government advocate shall take note of the said submissions and to move the government for doing the needful if any amendments are required in terms of the judgment of the Supreme Court of India. Next paragraph. The pursuant to the previous order of this court dated 22/6/2023, the state has filed three affidavits in the matter. Two affidavits in the matter. First is by the one is by the Director General of Police Assam, and the other is by the
Judicial Department. No? Judicially, no, two, now two. No? On 2/8, we have filed two.
by the LA2. We will say judicial department, by the judicial department.
Judicial is not a party here. Judicial is not a party here.
By the judicial department, okay. Full stop. It appears from the affidavit filed by the judicial department that that the status report of vulnerable witness deposition center within bracket VWDC for short at different districts of Assam has been provided. Full stop. The learned senior government advocate shall seek instructions from the chief engineer PWD within bracket building about the current status of the said construction, with a request to the said authority to expedite completion of those VWDC where the work in progress is 70% and above, as per the said status report. Next paragraph. It has been pointed out by the learned senior government advocate that as per the status report appended to the affidavit of judicial department, in respect of the district of Karimganj, the estimate for the VWDC in the new court building was submitted to the district and session judge for counter signature. To stop. The registry through the registrar administration shall obtain instructions from the district judge Karimganj about the counter signature to the as to whether counter signature to the estimate has been given by the said authority. Full stop. The learned senior government advocate shall also obtain instructions regarding pending administrative approval in respect of certain VWDCs as mentioned in the status report.
Lordship, my lord, may kindly indicate serial 23, my lord. Serial 23 kindly indicate. my lord. Serial 23, kindly
23.
indicate that.
Acha, just add in the first paragraph where we have said about, no, not first paragraph, before that. The registrar administration shall take a report, there you add. The registrar administration shall also obtain the instructions in respect of the VWDC located at the establishment of district and session judge Lakhimpur, where the wherein it is stated that the work was allotted but not allowed by the court manager. To stop. The reason for not allowing the construction to come up shall be put up in form of a note by the registrar administration. Next paragraph. The learned standing counsel for the High Court, Mr. H.K. Das, as well as the learned counsel for the petitioner, shall go through the affidavits filed so far in this PIL, and they shall give their concrete suggestions in form of a note for the works that has to be initiated to with their suggestions for the work which is required to be done, so as to implement in letter and spirit the judgment of the Supreme Court of India in the case of Sampurna Bevra within bracket Supra. Stop. Next paragraph. As agreed to by both sides, this is the matter on 24/8/2023. मैं दोनों में तो बिल्कुल हो उधर तो बिल्कुल बिल्कुल ये है ना
Well, the records are voluminous. well, I have find that some page numbers, Lordship's copy and our copy is not matching. But I'll take note of Lordship is having an index. I'll take note of that. Okay.
yes.
Pablo.
Just a moment. This PL1. What is to be done with this PL1?
But both these matters are Lordship is taking up together.
No, I understand, but what is the order required to be passed here? Because this is being, we are maintaining a separate order sheet here.
So far as PL1 is concerned, we are on the fact with regard to VWDC. They have given a report, my lord. Lordship can observe that they will submit the updated copy, and I'll also get the instructions from the registrar.
Okay.
BW
Is
this
index
person
right?
already passed the order.
But Mr. H.K. Das, learned study counsel for the court. And Mr. D. Nath, learned senior government advocate appearing for the state respondents. Next question. The learned senior government advocate has submitted that the status of the VWDCs has been given in form of an affidavit in the connected PIL 60 of 60 of 2019.
90.
Full stop. The learned standing counsel for the for this court is at liberty to collect the status report of the VWDCs from the registrar administration and give his suggestion in form of a note. Next paragraph. In the meanwhile, the learned senior government advocate shall also take note of the contents of order dated 22/6/2023 and shall inform the court as to how the state proposes to secure the safety of vulnerable witnesses if deposition centers are located outside the existing court building and to avoid exposure to the vulnerable witnesses before they actually depose in the court. Next paragraph is agreed to by all sides based on 24/8/2023.
Yes. Lordship. With lordship for permission. But since my learned friend is taking the information from the courts, but what is coming to my mind? In fact, I asked them why 17 is already done, rest 5 is under process. They said that we have considered the number of cases where, so on the priority basis we are going. If the figure comes out, then also we can just systematically we can go because we have to do in all the districts. It is there is no second submission to that. But while going through, because 17 completed, others are going on priority basis, which we can give priority to considering the number.
It's okay. We are not challenging the wisdom. We are not questioning the wisdom of the authorities in doing so. We are not even questioning that.
If the information comes from his side, because he is taking the instruction from the field.
Ah.
That
Share it with him.
number of cases are
We share
there,
it with him.
large number of cases.
No, the data is same.
Here,
I can tell you, the chart which you have given will be the information available in the registry
yes.
because insofar as the PW chief engineer is
In
concerned.
terms of cases.
Cases.
uh,
Acha, cases.
In terms of
saying that
cases,
there
because
okay.
vulnerable
In
witness
terms of
deposit
priority.
centers.
Okay, you get the information and share it with
Yes
us.
to know how many pending cases, but what my
Yes.
submission, I'll find it, but my submission is that it is the responsibility of the state to give the
No,
infrastructure.
you see,
That-
we all
that's
have,
there.
we all have certain, what you call, deficiencies. The state may face financial crunch in doing it everywhere at same time. Correct. So if supposing, let us say for an example, a district X does not have a child offence case registered. So what is the fun in directing the state government to expedite and complete that construction where the cases are less? You see, there can be an alternative
Only
where
5 left, to my knowledge. Guru.
whatever
Yes,
be,
Guru.
but once
So
he's asking the data,
Lordship, I'll find
We
it.
can-
I'll
we can-
find it.
no, you don't have to file it. You just have to share
I'll
it.
just- I'll
Yeah,
share me.
yes.
Yes.
If there is a district, but at least if a district is there where a lot of cases are there, but the work is very slow, so that we can expedite there.
Correct. It's not an invalid point.
Yes, sir.
And just get the data and share it with him.
Yes,
No.
yes. I'll get it.
Let's just type on that. As suggested by the learned senior government advocate. The court is inclined to permit him to collect the data of pending POCSO cases from the registrar within the judicial.
Please to file.
In this
This
33
was
districts.
so after that.
Not-
So this data will be in judicial side. It will
Yes.
not be in the administrative.
Correct.
So 24th then.
Lordship, I'm
Uh,
obliged.
i-
In the meantime, you just
What my brother has said, please do it because since we are monitoring the VW
This-
the witnesses center, be prepared with the what you call the integrations which you have to point it out before us. So that on the next day, we don't spend so much of time in understanding,
Beforehand, yes, my lord.
in reading the affidavits and then telling what to do, what not to do.
Lordship.
But that part, reading the affidavits and all, you do it and then you just tell us what is your suggestion.
Yes. I'll give you a bullet point, my lord. It
Huh.
will be one page, my lord, nothing more
Huh.
than that.
Because we don't intend to spend so much of time
It's not required.
on the next date.
Yes,
So if you are well prepared in advance so that
yes.
our time can be shortened.
Definitely, correct. Definitely.
item number 3 for hearing.
Deep, your lord.
All right.
Yes.
Here, it's a case of challenging a rule, madam. And in this case, it's whether the AG should appear, madam, but AG has a personal difficulty today, madam, he's out of station today. If Lordship could accommodate that on any other date on Thursday next. madam.
No, because it's a special bench.
Madam,
We are
that's
fixing matters on 24th. Do it on that day.
24th, not 16th.
Both sides are really represented. On the prayer made by Mr. S. Bharat, Leonard, standing counsel for the
GMC,
GMD,
GMC.
GMC. Matter stands adjourned today. List for hearing on 24/8/2023. The affidavits have been filed.
Lordship, at that, I have overlooked my lordship, will give the liberty, I will file my opinion with him.
No, because you see, when we are fixing it for
Lordship,
hearing, you'll have to do it within
I
a
have-
week because
I apologize.
they'll have to respond if required.
In advance, I will file my lordship. There is always two paragraph affidavit, my lordship.
No, we'll give you 1 week's time
Lordship.
to file it. Just before that, you write. On the prayer made by Mr. By the learned standing counsel for the GMC. 1 week's time from today is granted to file affidavit in the matter.
This is additional.
Huh?
Additional. affidavit.
Additional affidavit in the matter. So as to enable the learned counsel for the petitioner to obtain instructions if required and to file reply if so advised. Within a week thereafter. Within a week, you do it. Incidentally, few days back, I had to go to a doctor because I was not well. And he checked me up and then he said, he checked me and then he said, that, sir, you don't have a heart. He did not find my heart. And perhaps that is why this time the criminal bench is given to me.
No, I think not, lordship. With all respect, lordship, your lordship have,
I don't have a heart.
and apart from that, lordship, if these two lordship are evidence, consider, maybe mistake on the part of
I will
the,
direct expeditiously this paper book to be prepared and we'll take it on.
Yes,
break
your
because once there is an evidence
sir.
which is
apart
there.
from that, lordship, the weapon which was used, lordship, only 3 battery torch, lordship.
Huh?
And that also not seized by the police, lordship. That was not also seized. Lordship, as per evidence of IO, lordship, kindly pay the lordship, PW. PW 11, lordship. Lordship in the cross, the alleged incident occurred. There is no separate GD entry in the connection with the alleged incident. The PW1 Meena Bibi Ansari did not stated me that her son-in-law was assaulted by one unknown person also with a small weapon. She wanted to disbar the accused person personally from assaulting her son-in-law, that her daughter was
able to disperse that there was bleeding from the mouth of her son-in-law. PW7 Kholiluddin did not stated me that he had came to know from the Halima Begum that the accused Rahman Ali killed Islamuddin. I did not seize any weapon alleged used in the incident, Lordship. It is not a fact that I did not inquire the incident properly and file the charge sheet without proper investigation.
Mr. Mazumdar, it doesn't help you. The reason is cross-examination of PW10, who is the doctor. Correct. The only question you ask the doctor is that can this injury happen when somebody falls from a hillock? His reply is some of the injuries may be caused to a person if that person falls on any hard object from the hillock. So therefore,
Actually-
it is no. You say it is
Sorry.
your suggestion that he fell down.
Lordship.
For that, you did not lead any evidence to show that this person fell down from the hillock and got injured. And therefore, when everybody says that you have assaulted him from by this torch, and you did not ask the question to the doctor
yes.
that
Or-
whether such an injury cannot be caused by way of this torch, that means other facts are admitted.
Lordship. That this honorable court, Lordship, have kindly
No, because you
considered,
will have to respect the principle of res ipsa loquitur.
Lordship,
Because if it is possible to have an injury with this weapon,
Lordship,
then you have to show that it is impermissible for the court to arrive at a conclusion that the injury of this nature cannot be made by way of a torch.
Lordship. Lordship, on that also, Lordship, the injury part, Lordship, that is also very,
No,
Big-
injury is very serious. One contusion measuring about 1 cm into 3 cm on left cheek, below the lower eyelid. One contusion
upper
3
left side,
centimeter into 3 over a left side of nose, nasal bone fractured.
Lordship,
One abrasion and contusion in backside of right side of neck in the middle part, and one contusion 2 centimeter, 0.2 centimeter into 0.2 centimeter in the front,
Lordship,
mid front chest of all. You see, the reason is that 3 battery charge
Lordship.
is something which I see daily.
That-
Because the sentry which I have in the bungalow, they do the night duty with that torch.
Lordship, that but intention part also, Lordship, to kill Lord is also that will that can also, Lordship, in the intention part to kill, Lordship. If at all, Lordship, as per the her eyewitness is concerned, Lordship, that is also not reliable, Lordship. By 161 statement, Lordship, just though we cannot, but contradiction part, Lordship, how the learned court below considered that she is an eyewitness, Lordship. She is saying that her husband told her that somebody has beaten up 2 days back. And FIR, Lordship, was lost after 3 days. And that 161 statement was on 14, Lordship.
But this is no cross-examination on that point. Absolutely, you are silent on that point.
Lordship,
The date of filing of the FIR, you did not cross-examine
Yes.
the IO.
Lordship.
The witnesses who gave that FIR, you
Correct,
did not
Lordship.
cross-examine that the
Correct,
witness-
correct. What
that
is
the
mistake,
evidence,
Lordship, I cannot
mistake,
improve, but with
that
all
the
respect,
assault took
Lordship.
place 3 days back.
Yes,
Nothing is there in record.
Lordship. That part can be considered, Lordship, because a man may not be, Lordship.
You see,
And
you show me, you see, since I'm dealing with with this matter in respect of bail,
Lordship,
you have to show us that despite this evidence on record,
Lordship,
will be otherwise entitled to bail.
Lordship,
Because the parameters now is that after the conviction,
Lordship.
I must arrive at a satisfaction that
And yes,
the story of the prosecution is highly improbable.
and that about the presence of eyewitness PW2, Lordship, is, Lordship, not at all, Lordship, with all respect, Lordship, as per her statement as an
Course,
impaired witness.
plea he can take up while arguing the
No,
main appeal for
It will
hearing.
go to the merit of the matter,
Yes,
because
Lord.
this is something I'll have to evaluate the evidence,
Lordship, please.
brother. Let us have the paper book prepared. For Mr. K. Mazumdar, learned counsel for the appellant, as well as Ms. B. Bhuya, learned senior counsel, and APP for the state. Instructed through.
Lordship,
Instructed through.
I couldn't get it.
I-
Assisted by my M. Chakraborty. M. Chakraborty.
M. Chakravarti, learned counsel. Next paragraph. We consider the prayer for bail in this interlocutory application. Most of the court is of the considered opinion that the effort which should be taken to examine the evidence of the witnesses, the appeal can also be disposed in the same effort. So accordingly, the court is inclined to direct the registry to prepare a paper book expeditiously. Preferably within a period of 4 weeks from today.
Lordship.
Actually, in the criminal appeal, the cost of the paper book has to be borne by the appellant.
Sometimes, yes, sometimes they,
But Lordship, with all respect, Lordship, he is not in a position to Lordship. He is a very poor person.
Registry on
Lordship,
your
tea garden
own
level, Lordship.
Cost I could give now again. List the matter after 4 weeks in the orders column. In the meanwhile, if the paper book is prepared, the copies of the same will be served on the learned counsel for the appellant as well as to the learned APP. And in that event, the matter can be listed for hearing. For orders, in orders for if paper book is not prepared.
Much obliged, Lordship.
oblige.
Series of 3 number, 1 number 2 number 3 number.
Three to five.
May I please, Your Lordship? There was delay in filing of the appeal, my lord. 30 days delay, my lord. Actually, notice was issued, but somehow, my
Well,
lord.
notice have not been served upon me. In fact, there are 2 analogous appeals. That is,
Here for the informant.
I'm for the,
Matrimonial appeal, my
Petitioner.
lord. He is for
I'm-
husband, my lord.
I'm for the husband. It's a
You're
matrimonial
for the
appeal.
husband. Oh, acha. Oh, okay. This is a matrimonial appeal.
Nice.
You give a copy to him, take it up next week. Give a copy to him.
I will give me a copy note. Yes,
You take it up next week. then.
next week, yes, sir.
I'll issue a notice. In the meanwhile.
I can accept.
Actually,
I think notices were already issued, my lord. It did not receive me.
it
So
was
it
received by
is
the
why-
wife, my lord.
Wife is
Oh,
second
acha.
the
Notice is
appellant.
already issued. Okay. No, okay. Okay. I did not notice it. So, Mr. P. Kotoki, counsel for the applicant. Mr. BD Dekar, counsel appears for the opposite party. And access notice on his behalf. Get a copy of this interlocutory application. Along with the connected. The memo will be also served on him in the rest of the day. So the notice is made returnable on. 10/8/2023. Mr. Kotoki. But 30 days delay is only there.
In all probability, we'll concede, my lord. I haven't had the application. Obliged.
Mr. Kotoki. Mr. Kotoki. Since I'm not aware, I'm asking you.
My lord.
Why this names have been masked in the cost list?
Perhaps it's a new rule in matrimonial.
Matrimonial appeal, my lord, but there was a direction of ethics. code.
Okay, I'm not aware of this. Huh? No reason, huh? Okay then, okay, I'm not aware of it, that's what I'm asking.
Only case number is there. From there, we have to relocate them actually, which case we
Okay.
have done.
Since
Yeah,
I'm
we
not
can, I
aware,
can
I'm
cite it
asking.
now, but maybe that is direction of efforts for me. Start closer than.
Okay.
Obliged.
So at times it will be difficult for lawyers also to,
The lawyer's name is there, case number is there.
no,
ma'am.
no, means at times
Yes.
at times it will be difficult for lawyers to identify the case and then say what is the matter about. I'm just asking for that reason. Using the cost study, if I see the name, it is easier for me to understand
yeah,
that
I
I am
understand.
here.
Obliged.
Supplementary cause list, item number 10.
May I please your lordship, my lord? I filed this IA for extension of an interim bail order granted to me for 2 months, my lord. And under very compelling circumstances, I have to file the present IA 667, my lord. By this I am praying that my bail which was granted by your lordship on 26/5/23 in IA criminal 760 of 22, my lord. Connection is also. Page 23, your lordship will find it. The relevance starts at page 24, my lord. Shall I read?
Yeah, we're just.
By
Yes,
this
yes,
order,
please,
my
sir.
lord, dated 26/5/23, I was granted interim bail in a pending criminal appeal for the treatment of my little daughter, who is aged about 30 years and is suffering from blood cancer, my lord. So there is no male member because the mother is 45% physically having some problems, my lord, handicap, my lord. I have annexed that certificate also. Considering that aspect, my lord, I was allowed to come out from jail for her treatment in the Vigorua Cancer Hospital, my lord, which I have annexed the documents also. And accordingly thereafter, it is seen that, my lord, for her better treatment, we have to take her to outside the state. So we have taken an appointment at Apollo Galvitz, my lord, at Calcutta, my lord. And for that, I have also booked my ticket, subject to your lordship's extension of the bail order, of course.
You see, without hearing both sides,
But they are here.
no, it's, what I'm saying is without hearing both sides on the merit of the matter, I find that there's a order of the Supreme Court of India attached in this
Yes.
application.
No, earlier, my lord.
Huh? But you see,
We have given the sequences, my
no,
lord.
it's okay.
We have mentioned
But this
everything.
Supreme Court order contains a direction that you will surrender with
Right.
forthwith,
That-
without, no,
that-
whatever I'm saying. You see, the direction is to surrender forthwith. Therefore, if for, even for a purpose of fresh bail, once you surrender, then only we can consider that application for
Upcoming.
extension.
Your
Because
lordship
that-
will
that-
see that Supreme Court bail order was that when this honorable court did not extend my order, my lord, then being agreed, my lord, the party went to the Supreme Court, my lord. Supreme Court twice extended that, my lord. That order is a past history, my lord. Thereafter, I surrendered. Accordingly, I was taken into custody. Then suddenly I was given an information from my family member that a girl has developed certain problems, my lord. She needs immediate medical treatment. Then I filed the miss case on 22, my lord, phase 1. That's earlier, my lord. If your lordship will see the dates, my lord. Due to non-extension of the interim bail order, my lord, the petitioner was compelled to go to Supreme Court for extension, my lord, which was granted twice, my lord.
If your lordship will see this orders, my lord, at page 18 of the Honorable Supreme Court, my lord, it is way back in 16/8/21.
21.
21, my lord.
Hmm.
Today we are in 23, my lord. That I have complied with, all is done, my lord. Thereafter, I was granted, after 2+ years, my lord, I was granted ad interim bail for a limited period of 60 days. I took.
Yes, Mr.
Yes.
Yeah, you're opposing it.
I am for the informant side, my lord, wherein one of my family members has been brutally murdered by this appellant, my lord. Whatever my learned senior colleague has stated, it is on record, my lord. But the question out here is, my lord, that here is a petition that has been preferred again, my lord, because earlier, my lord, there are records, I'll place it before this honorable court, that first when a first petition was been filed in the year 2021, my lord, at the first date itself, we said that on humanity and human grounds, it should be allowed. There was no objections. But once it was allowed, it is become a modus of extending. Then it was pointed out to the honorable court. Then this honorable court was pleased to say that this is the last order, no extensions, surrender. Then they went to the Supreme Court. They have the right to go, my lord. It was extended by the Supreme Court, and ultimately he was directed to surrender. He surrendered. Now again, this petition has been preferred, my lord, wherein my lord will kindly see the order passed by this honorable court that they have annexed here in, my lord. That is the order dated 26/5 at page 24. The operative portion, my lord. 2 months were given, my lord. 26/5 is the order, my lord. 2 months were given at page 25. Now, after this order has been passed, my lord, next page at 26, my lord. 8 June 2023, he was released from jail. Now, my lord will kindly see from 8/6, my lord, when they went to, my lord, this Guwahati, they brought the child at page 29. After release on 8/6, at paragraph 13, specifically they have stated they have been released on bail on 8/6. From Nagaon to Guwahati, the child has to be brought. Page 29 on 21/7, my lord, we kindly see. They have so much of emergency, my lord, and the child has been after release, my lord. After 1.5 months, they bring the child to the Guwahati, my lord. And my lord, here has been a prescription of B. Borua College Hospital. Now, this is with regard to the money that has been paid, my lord. Refund above so and so, my lord. What treatment they have got in B. Borua Cancer Institute, nothing has been annexed. Next page, my lord, will kindly see. At page 30. Now, they have taken an appointment on 14/8. At Kolkata, they have annexed this particular document wherein their surrender, they have to surrender by, my lord, 7/8, my lord. They have to surrender. And they have taken an appointment after the surrender date, my lord.
No, we have not taken, my lord.
My lord,
Hospital
whatever
has
it
taken.
is, my
It
lord,
is not-
kindly see, my lord, they are released on 8/6. They doesn't bring the child or take the child to Kolkata. Because if your lordship see the High Court's order, it was specifically, child has to be taken to Calcutta. They didn't take the child to Calcutta. They brought to B. Borua Institute, my lord. When? On 21/7. And thereafter, now they are playing for Calcutta. On these facts, my lord, I leave it to your lordship, my lord.
My lord, I'd like to point out 2 things to counter his submission, my lord, which is not based on records, my lord. Firstly, at page 25, your lordship will find that the Honorable High Court never directed that I have to take her to Kolkata for the better treatment, of course, my lord. So first treatment was where the base hospital is the B. Borua Cancer Hospital, my lord. And if your lordship will see the documents, my lord, I am in B. Borua going for treatment since 9/5/2018, page 28, my lord. Since 18, my lord. It's not because of the case or for something else, my lord, that we have manufactured this document. This is a government official document. PP is here, can be verified, my lord. And we have come, why, my lord, late, my lord, a bit of late happened, my lord, because we are released subsequently after 8 days of our bail order, my lord. That, my lord, money is a issue, my lord. A person is behind the jail. my wife is disabled person, my lord, specially able person, rather will say. And in that, even the daughter is all alone at the mercy of the mother, she cannot do anything, my lord. That certificate I have annexed, my lord. Considering all that, if your lordship will turn to page 22, my lord, Annex 4, my lord, some tragedy struck some family very badly, my lord. At page 22, if your lordship will see, my lord, that the wife, my lord, that Omita De, my lord, she is 45% disability without periodically handicapped person from her childhood, my lord. So in that event, my lord, when I was released from jail, my lord, I have to collect money, my lord, from my relatives. I have to procure the source, my lord, of taking her, bringing her to Guwahati, my lord. Because there is no source of income except the husband, my lord. Since he's behind the bar, my lord, he doesn't have any such fund, my lord, that he can immediately bring the girl or take the girl to outside the state for better treatment. So when it was shown to the hospital, my lord, at B. Burwa Cancer Institute, my lord, she is okay, my lord. Now, for the satisfaction of the family member, my only child, my lord, I want to protect her by any means, my lord. And I collected certain money from my family members. I have stated at para 14, my lord, if your lordship will permit me, page 10. I'll just read for your lordship's time convenience, my lord. That the accused applicant begs to submit that he is a poor person. It's a very hard to arrange the necessary expenditure for treatment of his minor daughter Priya De. The accused applicant, after release from jail, he immediately approached his relative and friends to arrange money for the treatment of his daughter Priya De. And after arranging some money, he immediately came to Dr. Bhuvneshwar Bora Cancer Institute Guwahati for treatment of his daughter, and her condition did not improve much. So now, para 15, my lord, considering that aspect, my lord, he has decided to have a mental satisfaction that no untoward happens to my daughter, my lord. He has taken got an appointment from Apollo Glenrex Cancer Hospital, Calcutta, and accordingly, he got an appointment on 14/8. Appointments are not fixed by us, my lord. It is the ability of the vacant date from the hospital, my lord, that appointments are given. So I could get an appointment on 14/8, and I have accordingly booked my ticket also, my lord. And if your lordship permits me to extend a bail, my lord, then I can make my journey, my lord, and I can take care of my only daughter, my lord, only child. Father, just imagine a situation, my lord, father is behind the bar, mother is physically disabled, and the child, aged 13 years, the little angel is suffering from cancer. So in a very precarious situation, my lord, I have to move this application for extension of time. I'm not asking for any permanent bail or for a long period, my lord. My prayer is only to release me for further 2 months, my lord. So this blood cancer treatment, your lordship knows sometimes it suddenly falls down, my lord. The blood is produced, my lord. Sometimes he is all fine, my lord. Suddenly the production of blood, so red cells drops down, my lord. It's not a hearing also. This will be 8, 6, 8, 8. So it's 7, 9.
It's my duty to point out to this honorable court
that I made my submissions on the basis of this honorable court's order at page 24, my lord. Paragraph 3. Case of the applicant has been mentioned. The applicant intends to take his daughter to Kolkata for further treatment of his daughter, and therefore the present application has been filed praying for inter alia. And this is order dated 26/5, for which 2 months was given.
That appointment was not there. Preliminary checkup to Kodiluthu, whether we can take her to Calcutta or not, my lord. Preliminary report at Guwahati, my lord, was necessary, whether her health condition permits to be taken to outside the state or not, to take the rigor of the journey or not, my lord. Thereafter, it was decided to go, my lord.
Mr. Kamar,
Yeah, my lord.
the difficulties are, once we read the orders of the Supreme Court of India, then granting of extension of time becomes very difficult. You see, come to page 20.
That's true, my lord.
Come to-
I'm not
come to
asking
page
for
20.
mercy for my liberty, my
No,
lord.
it's okay. You can come to page 20.
Yes, my lord.
The last paragraph.
Yes, my lord. I'm aware, that's why I have not suppressed anything, I have mentioned everything, my lord.
There will be no further extension of time.
No, that is for that period, my lord. That's what I'm saying. This is a new development, my lord. All these things were
No,
considered.
that time also it was, she was
Yes,
suffering
madam.
from cancer.
Yes,
She was
She's
suffering
still
from
having
cancer.
my
It's a
lord.
continuing.
she's still not cured, my lord. With all respect, she's still, if your lordship will see, the latest medical certificate, page 28, my lord. The certificate given by the Bibura Cancer Institute on 21/7/23. They write the date very odd manner, my lord, American style. They write the date. 20, we'll have to read it from the back. 21/7/23 certificate was issued. It is saying that certified that Priya Day, the care of Bipul Day father, aged 13 years, female, hospital registration number such, is diagnosed as B all and is under treatment in this hospital from 2018 May 9 till 21/7/23. So I am a cancer patient since 2018, my lord. And this happens periodical attack, my lord. As I have said, my lord, blood cancer cells, my lord, sometimes does not develop, my lord. The blood, sometimes blood transfusion has also become necessary. But right now, that was at that stage, my lord. Again, new thing has developed as I was informed. So I waited thereafter, my lord, since 2019. Thereafter only in 2023, I came out, my lord. After passing of the Supreme Court's order, my lord. That was on 17/8/21. Today we are in August 23, my lord, after 2 years of passing of that order. In between, I was in jail, my lord, since the Supreme Court order. My lord.
That second order of this Honorable Supreme Court
Yes,
was
ma'am.
not annexed in your earlier IA.
Well,
Is
both
it
the
so?
orders are annexed, my lord.
No.
Yes, we have taken, my lord, the honorable coordinate bench of this honorable court while passing the order, my lord, has taken that facts also into.
There are two orders from the Honorable Supreme Court. You have annexed the first one and not second one, where it was directed no further adjournment will be.
No, I think I have, my lord, if I read from page 24, my lord, the honorable High Court's order.
No, not
granting-
this, before earlier application,
Earlier application.
previous application.
Yes, my lord.
IS 7.
No, that was already there, my lord. This time, as it was not there, so we have brought it here. The honorable High Court, if your lordship will kindly bear it for a moment, page 24. The applicant has earlier approached this court on several occasions wherein interim bail was given from
No, no,
time
this
to
is not
time.
what my brother is saying. My brother is pointing it out that when this previous order of 26/5/23, page 24 was passed, in that application, which is IA criminal 760 of 2022, the second Supreme Court bail order was not annexed.
No, it was there, my lord. If your lordship will, can you bear it
Uh-huh.
for one moment, my lord?
Uh-huh.
The last bail was given by the Honorable Supreme Court on 9/7/21 till 16/8/22 and directed the applicant to surrender before the concerned jailer on 78. It is already there on the record, my lord. From the record only that was shown last time, my lord. Because these two order was subsequent, my lord. After the first order was there, my lord, again in the Supreme Court, a petition was filed, my lord, for extension of the Supreme Court's interim bail order, my lord.
They have mentioned about it.
We have mentioned everything in details, my lord. If your lordship will see that this first order was passed on 9/7/21, my lord, and the second order was passed on 17/8/21, my lord. We have mentioned everything in the earlier petition, my lord, and that was looked into by the coordinated branch, my lord.
They have mentioned, but not mentioned about the previous two orders. They are silent 760.
No, the second order is not mentioned here.
Not mentioned.
Order of
9/7 is.
order of 17/8/2021 is
So
not
both the
mentioned.
orders were there, my lord, if I remember it, I'm just checking it.
Just one order is there, last order, 9/7.
That is what we are pointing out.
Yeah,
Yes.
absolutely, your lordship is absolutely correct, my lord. But the facts remain that we have annexed everything now, my lord.
That time it was not.
Yes, sir, maybe, my lord. My junior missed it as usual. Yes, 1%. Same thing. again. Junior को जो 1%.
Within a few months.
Liver petition को more certain will be right there.
Page 20. Obviously, we were prescription.
तो वो लोग देख नहीं जानता मैंने ये हो तो नहीं क्लाइंट ना है कि जाने नोबल क्लाइंट मोर तो खाली मुझ से नहीं होगी ना की बात दिशा ना जाने
Everything.
तो देखो तो होई तो
Main to get your family.
तुम्हें वो डिटेक्टिव पढ़ा अपन या
This is B. I think we'll have to give a bail to him.
Leave it to your
The,
lordship.
there's a reason for it. Come to page 28.
20, yes. Diagnosed as ball,
B, B all.
be all
B is,
that I am not.
B is called B cell.
Okay.
B means B cell
blood cell
and B cell is B lymphocytes.
Oh.
It says, the net says, B cells help to protect the body by making protein called antibodies.
Okay.
The antibodies attach to germs like bacteria, viruses and fungi in the body, which helps the immune system destroy them.
Okay.
So the girl's cancer has attacked that.
B cells, my lord. I am on this only, my lord. This medical certificate they have given me, no doubt about it, my lord. The test reports, the prescriptions. And my lord will kindly say page 29. B. Bohra Cancer Institute is one of the best in India, my lord.
No, you're right.
All rare machineries are available.
You're right.
And on 21/7, my lord, he attends Bhubaneswar Bohra Cancer Institute. On same day, B. Bohra also, my lord. But where is the prescriptions and reference referred to a for further examination, my lord? That is also not there.
I'll give all the
So their
documents
satisfaction,
to
they
Mr.
want to
P.
go to Calcutta. So no issues, my lord. But there has to be a time frame. This cannot be the
Yes,
way out, my
yes.
lord.
No, reference may not be there. You see, what happens is that, for example, take my case. If I have to become ill, and then take a treatment. I am the first line of treatment, I get it from my own doctor here.
Absolutely.
And he refers me to somewhere else and then I go there. It's not that I don't get
Good treatment
what you
here.
call, I won't be entitled to to go to a private doctor in the first instance,
Right,
but still it's always desired.
desired. Let
I
it be,
go to
my lord,
the-
no issues, my lord.
I go to the government doctor first. He refers me to a private doctor and then I go there.
Right. Let it be, my lord, no issues from my side, but this should not be a practice as in this case, earlier case, my lord, from
2019.
2 months, my lord, it becomes 9 months, my lord. They didn't answer it to, they went to the Supreme Court also.
Cancer, we can't help it.
At that time, COVID was going on. That's why we have to do. Mr. Mia, if you felt.
No, but we'll make it clear that
for
next
the
time we'll have to surrender.
Yes, yes.
I'll do that.
The next year,
I'll
that
do
you have to
I'll
surrender.
tell my client, my lord, that give the best within this period of time.
But Mr. Z Kamar, senior counsel, assisted by
Estate by
KD Sharma,
KD Sharma.
counsel for the petitioners. Sorry, applicants.
Anand, তোমার memorial করতে পারি। GMC.
Also had Ms.
Not
E.
fine.
Begum Leonard APP. As well as Mr. A. Bhuya Leonard, counsel appearing for respondent number 2 informant. Next para. This, by filing this interlocutory application under section 389 within bracket 2 CRPC, comma, the applicant is seeking suspension of sentence for a further period. Of 2 months on humanitarian ground, so as to enable him to provide necessary medical treatment to his minor daughter, aged 13 years, who is suffering from cancer, in the bracket B dash ALL. Full stop. Next paragraph. The learned counsel for respondent number 2 has opposed the prayer for bail on the ground that the applicant has been regularly moving this court for bail on the ground of giving on the ground of providing medical treatment to his daughter. Full stop. It has been pointed out that on the previous occasions also, the petitioner had approached the Supreme Court of India for grant of bail. And that while granting bail to the interim bail to the petitioner, the Supreme Court of India had ordered that on completion of the period of interim bail, the applicant would have to surrender before the jail authorities. It is submitted that the applicant was granted interim bail by this court by order dated 26/5/2023. And although the applicant was released on bail on 6/2023, he did not immediately avail the facility of treatment to his daughter at Guwahati. It is submitted that the applicant seeks to take his daughter to Calcutta for treatment, although there is no referral made by the hospitals at Guwahati for such for availing treatment out of the state. Next paragraph. Next paragraph. It appears from the contents of the order 26/5/2023 passed by this court in IA criminal 760 or 2022 that the minor daughter of the petitioner was suffering from inverted commas non-dash Hodgkins HODGKINS lymphoma LYMPHOMA and by the current medical certificate dated 21/7/2023 issued by Dr. B. Barwa Cancer Institute. Daughter of the petitioner is diagnosed as inverted commas capital B, next word, all ALL, which appears to be the short form of capital B dash cell acute lymphoblastic LYMPHOBLASTIC leukemia LUKEMIA. Next, accordingly, considering the projection made in this interlocutory application to the effect that the wife of the petitioner, namely, which page? Wife's medical certificate, where is that?
Which one, my lord?
Wife of the petitioner,
My lord, that is at page, my lord. 22, my lord. Annex of 4.
projection that the wife of the petitioner, I, the mother of the. No, mother's condition.
Yes. Mother, my lord.
Anita.
Anita Day, my lord.
24.
22, my lord. Annex of 4.
Mother of the wife of the petitioner, I, the mother of the ailing child, namely Mrs. Anita Anita Day is diagnosed of 45% disability, orthopedically handicapped since her childhood. Notwithstanding the objection made by the learned counsel for the respondent number 2, the court is inclined to extend the interim bail granted to the petitioner by order dated 26/5/2023 for a further period of 30 days. Till 7/9/2023. Moreover, comment is provided that on 7/9. No, on 8/9/2023. The applicant, namely Vipul Day, shall positively surrender before the special jail Nagaon without fail.
Session judgment.
Session judge.
Huh?
Session judge, I'll go directly to jail, my lord. No issue. Maybe like this, my lord, I'll directly surrender before the jail authority and I'll intimate the court also.
Next. And produce a certificate of surrender before the jail authority before this court. Then this interrogatory application stands disposed of in the criminal appeal right. That's and so.
Right.
As the paperwork is prepared.
Paperwork ready, man.
There's this appeal for hearing on such a date.
Any date.
Any date after I come back, my lord. Because it will be fair, my lord, that behind the bar, the appeal should be heard, I think.
You say a date.
Well, somewhere in September last or October 1st.
Agree to a date. Agree to a date. Give a date. There's a calendar in front of you.
28
Of
September.
that will do much. That will do.
28 September 2023.
Much obliged, my lord.
Because Mr. Bhuya, you may not know, but you will have knowledge of it.
My lord.
I what you call medical reading medicals is my pastime.
Yes, my lord. Very important, my lord, to know, my lord. In gynae cases, luckily my sister happens to be a gynecologist. She
Yes,
helps
yes.
me in medical science. But so far with regard to orthopedics, blood cancer, my lord, very limited knowledge, my lord.
My lord, we always say, my lord, as a lawyer, my lord, actually we are jack of all trade, master of none, my lord. We have to know little of engineering, little of medical.
And
medical
handwriting
legal,
expert,
Everything.
and then ballistic expert.
All
What
little,
not, my lord.
may not be master of anything, but jack of all.
It's required.
It's required.
That's required. Good enough.
6 and 7 for hearing.
Yes.
My lord, there are two cases.
Yes.
One by common judgment, two cases were disposed of, my lord. One, my lord, for divorce filed by the petition respondent, and one for restitution of conjugal rights filed by the wife, my lord, the appellant. The family court case number 107/2013 was filed by the husband for the dissolution of the marriage under section 13, my lord. And the matter appeal 1422. This is against the case number, family court case number 311. This is filed by the wife for restitution of conjugal rights, my lord. A common judgment. And so 2 appeals are there, my lord. My lord, I pray, my lord, my learned can to start first, my lord.
Why?
My lord,
Why I am respondent, why I should?
my lord, all right.
You have to plead your own.
My lord, judgment,
Yeah,
the impugned judgment.
Just a minute, just a moment, if I understand it correctly, you are pressing for your appeal so far as restitution of conjugal rights is
Yes,
concerned,
my,
correct?
yes.
But then tell me one thing. It is on your complaint that this there a police case was registered under 323, 304, 379 and 498A, read with 34.
Yes, my lord. That is
Now,
the,
no, tell us a compelling reason why, despite so much of torture on you, you still want to live together.
my lord, see
Because
the,
your case is that the husband also threatened to set you ablaze. You were under threat to be put on fire. Correct. So with that background, please tell us the compelling reasons why you want to live together.
yes, my lord, that she is a Hindu lady, my lord. She wants her husband, my lord. Once she married and she wants her husband for all the time. That is one of the reasons. And the factual,
No.
the
You see,
factual
there's a
aspect,
reason.
my lord, there is a
There's a
difference.
reason why I'm asking you.
Yes,
This criminal case you prosecuted. You did not abandon this case.
yes, I admit I filed the cases, but circumstances lead to file these cases is different, my lord. The first issue, whether the wife left the house of the husband or the husband thrown out from her house, his house. This is the main question. That aspect has not been considered by the learned court below. Whether the husband thrown out her from his house or whether she herself left the house. Simple reading of the judgment shows that she left the house and then thereafter she filed the cases. For 498A, she filed FIR before the Women's Police Station. These are subsequent things, my lord. Circumstances demanded that she should go for a 498 case. She has not left her husband's house herself. The husband threw her from her house. So it lead. She has been forced to file these cases, my lord. But in fact, for no fault, she has been thrown out of the house. That aspect of the matter has not been considered in this appeal by the court below, my lord.
Second to the evidence.
In the divorce petition, it has been clearly said that she left on demand. She is a married girl from village Bihar, one of the village from Bihar. She has come to the Guwahati only before 2 months. She got married in the month of February and she in June 2011 she left. Is it possible? That aspect of the matter has not been considered. Court has came to the conclusion that she has come to the Madhubani railway station. With whom she has come to the Madhubani railway station? Whether she has come alone to the Madhubani railway station, whether in-laws brought her to the Madhubani railway station. Husband and in-laws brought her to the Madhubani. That aspect of the matter has not been considered. This factual aspect of the case has not been considered. My simple prayer before your lordship is, Lord, to decide the matter whether she has came herself or she has been thrown out. If she has been thrown out, then there is a case. If she came, my lord, herself, then there is a case is different. Yes, then the petitioner is entitled for the decree of divorce.
No, I not understand. You see, come to page 9 of the judgment.
Yes, madam.
Now you see, in this page 9
Internal page 9.
of the judgment,
Yes, madam.
in the first about 7-10 lines, you'll find the cohabitation between the petitioner and the respondent could not resume because the petitioner had ousted her from the matrimonial house in spite of several rounds of negotiation. So in the judgment, it is admitted that the husband threw you out.
Yes, husband threw me out. So I have a case. I have to file the case under 498A.
No, that's what I'm asking you. You see, it is not one, if you read the judgment as a whole, then you'll find your allegations are that you are not allowed to sleep with the husband, you are asked to sleep on the floor. You are not taken good care of by the husband, you are assaulted. And you are taunted of being a village girl, so there are, those allegations are there.
No, assault, why she has been assaulted? The reason behind assault is the dowry. They are demanding dowry and we could not fulfill the dowry. So I have been assaulted, my lord.
Yes, Mrs. Vaman, that is why I'm asking you. With all that background, what is the compelling reason for you to want to stay with the husband?
My lord, that's, I say, I'm a Hindu lady, my lord. I want to stay with my husband.
But when it is irritable breakdown of the marriage, when you yourself have prosecuted that even the Supreme Court. says
Because
constitutes
and
a
no fault
ground
of the
for,
petitioner.
divorce.
No fault of the appellant, my lord, she
No,
has been
it's
thrown
okay.
out.
But when you are prosecuting the husband on this ground of 304, 498A, it constitutes a good ground for divorce. How we can say that there's been no irritable breakdown of marriage and to restore the matrimonial relationship? That is the only point we are trying to understand.
And she, on the request of the respondent, she withdrawn the, my lord, this 498 case. And as there was no negotiation, thereafter is filed an application for revival of the case, my lord. She withdrawn herself the case.
You come to the evidence, your evidence. We'll continue at 2 o'clock.
Yes, ma'am.
Page 116 পড়া DW3 কি কইছে
কি কৈছে?
ছোৱালীৰ বাপেকে লৈ গৈছে ছোৱালী
Cross examination of Dilip Kumar Mishra recorded on Iman. This is in case number.
FC 107.
My lord, no, 311. Restitution of computer.
Yes. Yes.
Well, cross-examination of DW1, Dilip Mishra recorded on 19/11/18. My lord, this. My marriage with Mary,
1911.
19/11/2018.
DW1.
DW1, Dilip Mishra. In case number 311.
Dilip Kumar Mishra. Yes.
311 is the restitution petition.
Yes, yes. Just, I want to show one line here, my lord.
Yes.
My marriage with the petitioner was arranged marriage. I met the petitioner about 15 days prior to our marriage. About 10 days, I talked with the petitioner over phone prior to our marriage. Over phone, I found the petitioner to be good. After our marriage, we lead happy conjugal life about 2 months. They had lead conjugal life, my lord. We got married in the month of February 2011, and till May, our conjugal life was good. In the month of June 2011, the petitioner left the house, our home of her own. This is my question, whether she has left the house over herself or whether they have thrown me out. This is the question. That aspect has not been decided by the court below. Now I come to the petition, my lord, divorce petition filed by the respondent. Divorce petition, my lord, it is annexed as Annexure A in my 10, my taping 10, my lord.
Just a moment. You are aware perhaps that few days back, I made a comment in the court and it is what you call, the message is being circulated widely in the with the advocates in the bar. You are aware of that? You have seen the WhatsApp message? No,
No,
but it is for some time it is, I think that is a viral. No, that is viral in the bar.
actually,
I'll tell you why. That is relevant. Who is that EW1? Is that the earlier deposition you made us read?
No, now I want to come to the
No, no. Who was DW1?
DW1 in 1311. This is the husband, Dilip Kumar
He
Mishra.
is the husband.
Yes.
Uh, Can you tell me why this husband became DW? He is the plaintiff.
No, in conjugal rights, my lord.
No, this 311.
Yes,
FC
this is filed by
311.
the wife, my lord, for restitution of conjugal rights.
That is a petition under section 9 of.
9 of-
The Marriage Act for the restitution.
Oh, that is by the
of
wife.
Conjugal life
That is by the wife.
filed by the present appellant.
Now, first question. In a proceeding under section 9 of the Hindu Marriage Act, is there a legal requirement to frame issues?
Yes, this is a proceeding.
No, because it's section 9 is an interlocutory proceeding. It's not a main proceeding. So the requirement of issue being framed, I think would not be there. Because-
Issues framed, but issues are not discussed. Issues are
Where is the issue? Where do I find the issues?
issues in the judgment process. Internal page 11 of the judgment, my lord. 109 page in the, my lord, multiple 10. Multiple 10, my lord.
Starts from page. In your appeal, which starts from page, which is that page?
Internal page 11, lordship.
11.
Yes, paragraph 10, my lord. of the judgment.
Matable 10.
10.
That issue is also reflected regarding restitution in the judgment lordship. It is a common judgment.
109.
That is page 109, lords.
Ah.
The common judgment. Last para 11.
Para 10, my lord, on the basis of the pleading, after hearing both sides, both parties, following issues are framed in the divorce petition. Whether the respondent treated the petitioner with cruelty, whether the petitioner is entitled to get a decree of divorce. Then, my lord, in the case filed by the respondent praying for restitution of conjugal rights, following issues were framed. Whether the respondent without reasonable exercise withdrawn himself from the society of the petitioner. Whether the petitioner is entitled to get the decree of restitution of two issues were framed, my lord.
then you see, come to page 121. Para 33. Issue number 1 and 2 of FC Civil 311 of 2013. First is whether the respondent without
Yes.
reasonable excuse withdrawn himself from the society.
That issue has not been discussed, my
No,
lord.
no, page 34.
Mm.
In view of the discussion and the so-and-so following issue, it is found that the respondent has treated the petitioner with cruelty and therefore she is not entitled to so-and-so. So therefore, both the issues are decided in the negative and against the respondent.
Yes. Yes,
So it is against the respondent, whether the respondent without dispute, withdrawn himself from the society. So it is decided in negative, that means no. What does it mean? Both the issues are decided in the negative. The respondent without due clause is decided in negative. Issue number 1. He has withdrawn himself from the society. Without reasonable excuses, he withdrawn himself from the answer is no. Then how is it against the petitioner, against the respondent? This answer is wrong. It should be yes. Yes. Second is whether the petitioner is entitled to get dispute responded. Both the issues are decided against the negative. No. Petitioner is not entitled. No, but it is negative against the
it
respondent.
should be yes, my lord.
It should be yes.
Negative against the respondent.
Negative against the respondent.
Yes. That is why.
No, respondent is the husband.
Respondent has been in,
Divorce petition was filed by the husband lordship. And in a common judgment, in the initial paragraph.
No,
it
no,
is-
no. You see, para 33(1). Whether the respondent without reasonable cause withdrawn himself from the society. So therefore male. Husband is male.
male,
He is respondent.
311.
Before the family court, he was petitioner.
No, I don't know. I'm just showing you this paragraph. 33(1) says, what is the question? Whether the respondent without reasonable excuse withdrawn himself. Therefore, respondent is himself, he. That means husband has withdrawn from the society of the petitioner. Petitioner
No,
is
no,
wife.
no, Lord.
Yes, yes, my.
This
Lordship
is,
is right.
this is regarding restitution of the conjugal life. Case number lordship 311
I don't know,
30.
I'm just reading the language. What does it mean is it will come next. I am reading the text of 33(1). 33(1) says whether the respondent without reasonable cause.
Respondent is here, it means wife.
No,
Yes, lordship.
withdrawn himself.
No, that is
Withdrawn himself.
herself. It ought to be herself.
Can't be.
No, lordship. Because your lordship will please to peruse the initial paragraphs of the judgment where the learned civil judge, family court judge has treated that the husband will be treated as petitioner and the respondent will be treated as.
So the
respondent.
question is wrong and the answer is also wrong then.
No, lordship. According to me, it is not wrong.
You see, now let us test
Next-
your submission.
Next,
Whether the respondent without reasonable cause, we read it petitioner. The petitioner without reasonable cause withdrawn herself from the society of the husband.
In restitution of conjugal life, what himself is correct because that was filed by the wife, restitution petition
Huh.
against the husband for the restitution of the conjugal life. That's why the himself word has been rightly used.
Whether the respondent, that means husband is the respondent or it should be a petitioner, according to you.
No, respondent without reasonable cause is drawn himself from the society of the petitioner.
So therefore,
Because
respondent-
in the
no, that means from in this question, it appears that respondent is the husband.
yes, in
Correct.
the restitution, because the allegation.
Respondent is the husband. And you
Yes.
see the answer down below. Hence, both the issues are decided in the negative and against the respondent. So that means it is not a fact that the husband has withdrawn from the society of the wife.
No, here lordship, the respondent means lordship, wife.
But wife is not withdrawn. It is not her case that the wife has withdrawn.
No, she has withdrawn. In the divorce petition lordship, the averments made by the husband is this, that without any rhyme and reason, she has left with her parents to her parents' house. That was the pleaded case of, and she is living there in her parents' house is last more than 10 years. She never came back. So that amounts to cruelty, mental, physical cruelty.
So himself is wrong, it should be herself.
Lord. Or man, so in law, herself, as per general,
No. It is difficult, getting me difficult.
no. As per general clauses act, lordship, he means she means he.
So that means wife will do for the society of the husband.
Lordship, the thing should be clear. And like to play the role, lordship.
But then if what Mr. Roy is saying is correct, then
No.
the answer is against the husband, against the wife. Saying that the wife has, it is a fact that the wife has.
While issuing the frame, my lord, issue was framed, my lord, put below treated husband as respondent in the case 311. That's why the issue is correct, my lord. Whether the husband himself withdrawn from the society of the wife.
Lordship, may we please to
And
come. Oh.
And in 34, para 34, as your laws observe that respondent has treated the petitioner with cruelty. This respondent means in general, these both are combined, common judgment. So initially, I said that petitioner will be treated as petitioner and the respondent will be treated as respondent.
Lordship,
You see,
Obviously, petitioner will be treated.
Petitioner
as
in
petitioner.
107 will be treated in whole judgment as petitioner, whether it is for 133 or in 107. A
so
respondent,
petitioner is husband or wife.
petitioner is husband as per this common.
Lordship, in divorce petition, husband is the petitioner. In conjugal restoration of the conjugal rights, the wife is the
I understand,
petitioner.
but it is a common judgment. That is why we are
Common
trying to
judgment.
understand.
Lordship,
My brother appears to be right in understanding that whatever reference is being made, the respondent is the wife
Wife.
and petitioner is the husband,
Yes,
correct?
yes, page 101, the learned family judge court had clearly para 2, page 101, Lordship,
Ah.
para 2. For the sake of convenience, the petitioner of FC civil case number 107, this is divorce petition. And the respondent of FC civil case number 31113 is called herein after as the petitioner.
Petitioner is
And the
husband.
respondent of FC civil case number 107, that is the divorce petition. And petitioner or of FC civil case number 31113 is called herein after as respondent.
Correct. So now this paragraph 34 judgment says, hence both the issues are in the negative and against the respondent. That means wife
Why?
without excuse has withdrawn from the society of the husband.
Yes,
That is the interpretation.
yes.
this issue has not been discussed, my lord. This,
No, discussion is there. Don't
my
worry about that.
discussion is there.
Detailed discussion is there.
Discussion is there.
No,
Let my
discussion
learned
is
friend.
for- My lord, I said discussion is for this judgment, my lord.
It should have been.
This issue, whether the respondent treated the petitioner with cruelty.
That is because the issue is just like the right. Now, he's saying that this was not. But the discussion is there. And the discussion is there in the previous, things, the discussion is there.
Discussion,
Only for the purpose of the issue, two separate issues are there and
entire discussion is as regard to the issue in 107, that is whether the respondent treated the petitioner with cruelty. Entire discussion is on this issue, my lord, and has come to the conclusion that the petitioner.
Actually, you may not be right. You come to page 121.
Yes,
Come to page 121. The first paragraph. The respondent filed 2 criminal cases against the petitioner and his family members for making serious allegation of torture, demand of dowry without any concrete basis, as appeared from the evidence on record. Moreover, she has withdrawn herself from the prohibition of the petitioner since so and so. Therefore, it is found that the action of the respondent constituted mental cruelty on the petitioner.
yes, yes.
That
this
means
is-
you
this is-
committed mental cruelty on the husband,
Yes,
and therefore the finding at para 34 makes sense. In
Yes.
view of the discussion above, it's
yes,
right.
yes,
So
but
decision
this,
has been made. You are
thi-
saying that no decision, no discussion was there. Decision is also there, discussion is also there.
this is the discussion as regard to this issue, my lord.
No, see, it depends on,
All right,
it
All right, even
depends
then-
on how the court writes a judgment.
my lord.
You see,
My lord, that is, I'm not in that, my lord.
Huh.
My simple prayer before your lordship is that whether this observation of the court, whether now lordship has pointed out that the respondent filed 2 criminal cases against the petitioner and his family members, making serious allegations of the true in demand of dowry without any concerted basis as appeared from the evidence on record. Moreover, she has withdrawn herself from the cohabitation with the petitioner since Iman. Whether this observation is true or wrong, my simple prayer is that the she has not left the house of the petitioner. She has been thrown out of the house of the petitioner. She has been thrown out by the husband and her family members. Therefore, the question does not come that she left the society of the petitioner.
Submission,
see, I,
And-
from this judgment, we don't get it. That complaint case 1088 of 2011.
It came subsequently.
No,
It-
it's
it came
okay.
Subsequently.
No, it's okay. But
If-
that case has been disposed of or not, we don't know.
Hmm.
My brother has read the brief. He says that it appears that the criminal case against the husband is still pending.
She has filed an application for revival of the case. That aspect.
So it is
I
still
know.
pending. My brother is right then.
Yes.
no, whatever my learned friend has submitted, that is not correct. Your
So
lordship.
it's
will
okay.
please to-
We will give you an opportunity. Let
Yes.
Ms. Burman complete her statement. Because since I have not understood the first part, I was trying to understand what is the finding of the court? Who is the petitioner? Who is the respondent?
Respondent,
Now
yes.
that is clear. Now we can proceed.
My lordship, I pray lordship may peruse, my lord, the divorce petition.
Ah, yes.
Divorce petition, my lord. Here, my lord. Paragraph 4. Page 26.
Page
26.
26. Yes.
Here said that after 1 month of coming to Guwahati, the opposite party started creating nuisance and did not pay any attention to her marital duties as also household activities. Not only that, the opposite party used to cruel with her old aged father-in-law and mother-in-law without any rhymes and reason. And here, my lord, in cross, just now I have read, put before your lordship, in FC case number 3-1 restitution of our lordship has got Dilip Mishra. Here they said they are good relationship for 2 months. This is a contradiction that has not been decided or that has not been, my lord. Then lordship will come. Para 11. Page 28.
Yes.
Para 11, they have said in the petition, my lord, thereafter on 15/6/2011, after 3 months stay in Guwahati, the opposite party left the home of the petitioner in spite of his several requests for her paternal home in Madhubani district in Bihar. And before leaving Guwahati, the opposite party took along with her all the gold ornaments that she has got in marriage without knowledge of the petitioner. She left for herself. They have said that she left for herself to Madhubani with the gold ornaments, but they have not filed any. Now I come to the cross, my lord. cross examination of PW1 Dilip Mishra recorded on 14/6/2017. I know the entire contents of my original petition. Our marriage was not a love marriage. Our marriage was arranged marriage, arranged by my parents. Before 15 days of marriage, I met the respondent and had talked with her in a home atmosphere. During our conversation, I asked the respondent about her education. I also had the conversation with the respondent over phone. Our marriage was purely arranged one. Out of the aforesaid 15 days prior to my marriage, I at least 10 days talked with the respondent. Before my marriage, the respondent showed me all the education.
Madam, just wait.
My lord.
No, it's okay. I'm hearing it.
My lord.
Huh.
This is the cross, my lord.
Huh.
Cross I have not annexed.
It's okay.
I have not submitted the said educational certificate of the respondent in instant case, as well as the said documents have been taken back by the respondent along with her. I am BCom graduate. We do conversation at home in our mother tongue, that is Mithali. After marriage, the respondent was accompanied with her brother, namely Akhilesh Jha, to Guwahati. It is not fact that I asked the aforesaid brother of the respondent to accompany us to Guwahati so that I can arrange job for him at Guwahati. We do not take Assam Tribune newspaper at our home, in Bihar, but we keep the same at Guwahati. I asked the respondent in the last part of May 2011 to read the Tribune newspaper. It is not fact that I institute the instant divorce petition, as the respondent does not know to read English. I have mentioned in my petition that the respondent is an illiterate woman, as she does not know to read and write. At the time of marriage, I know that respondent is graduate. I have mentioned in my examination in chief that I tried to settle the dispute between me and the respondent, but I have not mentioned any date and details of the same. I have mentioned in my own that the respondent is mentally unsound lady. I did not take the respondent to Mithali. The respondent, after leaving for Mithali, informed me about
Madhubani.
Madhubani.
The language.
Respondent, after leaving for Madhubani, informed me about the over phone. I have not stated the same fact in my cross examination in chief. I have not adduced any documentary evidence to prove the fact that we tried to settle the matter with the respondent. They demanded ₹5 lakh. I not mention the name of the person who made me threatening calls. I lodged FIR after receiving the aforesaid calls, but I have not mentioned in my examination in chief. I have not mentioned the exact date since when I stopped cohabited with the respondent. I have mentioned in my own that the respondent is suffering schizophrenia, physiatric disorder. I have not mentioned the exact date on which the respondent threatened us to kill by making us to consume poison. I institute a complaint case against the respondent after she filed the complaint case at Madhubani, as she took away the article without informing us. I did not submit the aforesaid complaint petition in the instant case. The respondent did not come to our home at Guwahati after June 2011. It is not a fact that we ever made any demand to the respondent or his family member. It is not fact that we took the respondent to Madhubani railway station and left her over there alone. It is not fact that I instituted the instant case as the respondent has my parents. It is not fact that I falsely made allegations against the respondent on her being mentally unsound person or suffering from any mental disorder. It is not a fact that I sought divorce from the respondent as she does not know English. It is not fact that I know that the respondent at the time of marriage only did matriculation. It is not fact that I, with the intention to remarry, have instituted this. My lord, they have said that she left alone. She left alone. In the written statement, what the wife said? Wife said that they took me to the Madhubani railway station. The in-laws and the husband took me the Madhubani station, and they left her there, and they went away. And finding no other option, she called her father and went to her paternal house. Therefore, my prayer is before your lordship, whether she has been left by the husband in the Madhubani station, or she alone left from Guwahati to Madhubani. That aspect of the matter, factual aspect, this is the factual aspect. This aspect of the matter has not been decided by the court below. Court below come to a conclusion that the criminal cases has been high cruelty is there.
In the petition for conjugal restoration of conjugal rights, what is your evidence? 311, what is your evidence?
Evidence on affidavit PWD 1.
Yes.
Evidence on affidavit PWD 1, my lord. I, Srimati Ragini Jha, aged about 26 years, wife of Sri Dilip Mishra, daughter of Sri Lalan Kumar Jha, resident of village so-and-so police station, district of Madhubani, state Bihar, by religion Hindu, nationality Indian, occupation housewife, do hereby solemnly declare and affirm that the statement made below are true and the best of my knowledge and believe. That I am the petitioner in the instant case, and as such, I am well aware, acquainted with the facts and circumstances of the case. That my marriage was solemnized with the opposite party, Sri Dilip Mishra, on 18/2/2011, as per Hindu rites and rituals, at my village, Bahar, police station, so-and-so district, Madhubani state, Bihar. After marriage, the opposite party took the petitioner to his house at Madhubani and started their conjugal life there. My husband, opposite party, also hailed from the village Arara, police station Arar, district Madhubani, state Bihar. That after a few weeks of my marriage, my husband, that is the opposite party, took me to Guwahati at FI Road, Kumarpara. And we started our conjugal life at Guwahati in our rented house, along with my mother-in-law, father-in-law, and two sisters. But gradually, my in-laws started to torture me both mental and physically on the plea of demanding dowry. And my in-laws also instigated my husband, that is the opposite party, to torture me both mental and physically. That at the time of marriage, my parents as well-wishers gifted me gold ornaments, furniture, many household utensils, and cash amount of rupees 7,50,000 only was given by my father by selling his land at Bihar. Moreover, one motorcycle, gold chain, 3 numbers of gold ring and cloth, etc. were given to my husband, opposite party, as gift by my parents. That after marriage, my husband, opposite party, and his family members started torturing me for fetching dowry in the form of cash and gold, and abusing me with secretary's remarks and my father for not giving car, fridge, air condition, etc. to my husband, opposite party, for which my parents were not capable of giving that. That due to non-fulfillment of demand of my husband, opposite party, and his family members started to assault and insult me on this and that plea, using slang and filthy languages which cannot utter in the civil society. In the month of June 2021, my husband, opposite party, and his parents took me to Madhubani, Bihar, to his house on the pretext that they were also going to their village at Bihar, and I can also meet my parents by playing fraud and keeping me in dark. Thus, when we reached at Madhubani railway station on 26/2011, they left me alone at the railway station, from where my father took me to my home on my call, and at that way they ousted me from my matrimonial home, and since then I am living at my parents' house till date. That I and my parents several times requested the opposite party husband to lead a peaceful conjugal life, but he did not consider our request and demanded further dowry as a precondition for accepting me. That finding no other way, I filed a case under section so and so Indian Penal Code in the court of Chief Judicial Magistrate, Madhubani, Bihar. But during pendency of the case, my husband and his family members contacted me and my family members to settle the matter out of the court and take me to my matrimonial house. As per their promise, I did not pursue the said case, and accordingly it was filed by the said court. But when after several meetings, my husband did not take me to his house after not perusing of the said case, pursuing of the said case, it is pertinent to mention herein that finding no other way out in the year 2014, the said case had been reopened and now pending in the said court as my husband, that is the opposite party, did not take me to his house for starting a conjugal life together. That while my father, including myself, trying to settle the matter, as at that time I was hopeful for restarting my conjugal life by forgetting and forgiving the past mischief for my husband. Surprisingly, I received a notice of divorce case filed by my husband, opposite party, before the honorable court, alleging some baseless allegation against me. Accordingly, I appeared in the said case and contested the same by filing my written statement in the said case being number so and so, before still pending before the honorable court. That being a devoted Hindu wife, I never want to divorce from my husband. The opposite party, as is in our society, marriage is a statement of and is a religious ritual, and I want to lead a happy marriage conjugal life with my husband, opposite party. My husband, the opposite party, without my fault, drove me out by deserting me in a cruel manner, but I want to go with my husband to lead a happy conjugal life as husband and wife. Hence, honorable court may please to direct my husband, the opposite party, take me with him to continue my happy conjugal life. It is pertinent to mention here that I have filed an application under section 125 before Family Court, Madhubani, Bihar, being embarkation of some so and so. And in the said case, the opposite party, my husband, has appeared and contested, and same after hearing the opposite party. The said learned court was pleased to pass an order by so and so directing the opposite party, my husband, to pay an amount of rupees 2,000 per month as an interim maintenance. 14, that I have filed the aforesaid maintenance petition as my husband, opposite party, was refusing me to pay any maintenance as I have not secure of income, source of income of my own, and I am still residing at my poor parents' house, becoming a burden of my parents. I pray before this honorable court that the honorable court may be pleased to direct my husband, opposite party, take me with him in order to lead a happy conjugal life. I never want divorce from my husband. My lord, my facts is that for no fault of me, why should I be declared a divorcee? Why should I take the burden of divorcee? What is my fault? What the divorce petition said? That I am illiterate. But he himself said that he saw the certificate before marriage. These are the allegations. Dowry admittedly 7,50,000 has been paid in the name of dowry or in the name of gift. It has been paid to the husband. It is not denied. This is fact. And for dowry, she has been thrown out and she has been victimized. Now they have claiming that she has left the house. Why I left the house? You brought me and thrown me out in the station. The evidence of the father said that, and uncle said that, they said just now, my learned friend said that you go through the evidence of DW3 that father brought from the native village of the husband. The daughter was brought from the native village of the husband. How can I reach the native village of the husband unless they take me? I went to Madhubani. I will go to my house directly if I left alone. All are false things, my lord. That aspect of the matter has not been considered by the court below, and court below has said simple case that she has left the house of her own. Then she filed the cases. She created mental torture, and therefore she is not entitled for any relief. This is the case. This is a simple case, but this is not a simple case. This is not so simple. She has gone herself and filed the cases intentionally. No, this is not. For her protection, she has filed the cases there. As she has been thrown in the railway station, she has some protection. She needs protection. This is my matter. Must have.
May I please, Lordship? Lordship, my learned friend has submitted that the husband parents took the present appellant Lordship by rail to Madhubani station in Bihar. And thereafter she was left alone over the platform, and then she called her parents, and the parents came and took her to her parents' house, Lordship. And other submission is this, Lordship, that the respondent, that is husband or his parents, demanded dowry and tried to set on fire, then to administer this poison, or all these are the allegations, Lordship. The first question which will come to the mind is this, Lordship, that if the husband or his parents want to set on ablaze the wife, the appellant Lordship, want to administer the poison, husband or in-laws Lordship, why she are interested for restoration of the conjugal life? And the submission made by my learned friend that the husband drove away the wife from the matrimonial house. It is absolutely incorrect, Lordship, and the learned trial court has given the complete finding regarding the cross examination of the DW3, who is the close relative of the Ragini Jha, that is the present appellant lordship. Lordship, may please come to the page 116 of the impugned judgment. Page 116, para 25. In this regard, I have also gone through the evidence of DW3, who is the close relative of the appellant lordship, who has deposed in his examination in chief that about 5-6 months after the marriage, the mother-in-law and father-in-law of the respondent took her to their village Madhubani from Guwahati. After coming to petitioner home at Madhubani, the respondent was taken to her parents' house by her father for few days to perform certain rituals which were to be done after the marriage. If the relations were so bad, lordship, what was the need to perform the rituals after the marriage? During the stay of the respondent at her parents' house, demand of dowry arose by the petitioner and his parents, and they told the respondent if their demand was not fulfilled, they would not take her back them to their house. After the said incident, the respondent was not taken back to matrimonial house. DW3 has stated a different story as to how and when this is important, lordship. DW3 has stated a different story as to how and when the respondent went to her parent home and started residing there. According to him, the respondent was taken to her home by her father from the house of the petitioner in his native village to perform certain rituals. That there are contradictory evidences adduced by the respondents with regard to her stay in her parental home. However, moreover, there is nothing on record that before filing of the complaint case in Bihar against the petitioner and his family members, the respondent had even tried to return back to her matrimonial house. So, lordship, the DW3, who is the witness of the wife, lordship, he himself says no. The parents of the present appellant wife, lordship, they had come to Guwahati and they took their daughter to Bihar, lordship. But the allegations in the WS and the whatever my learned friend has submitted, that she was forcibly driven from the matrimonial house, lordship. And this has been rightly discussed. Lordship, may we please to peruse the how the husband has been cheated. At the time of negotiation, lordship, I would like to submit one thing. The parties here are Maithil Brahmins. Maithil Brahmins. And
No, but you see, in the cross-examination which you made, irrespective of what the DW3 has said, your question in the cross-examination was that your mother brought you to Madhubani.
no, her mother.
Her mother. So it is not the father.
Either mother or father,
No,
that is
but-
not so.
But you see, but the fact is that that part in the cross-examination is denied. So in fact, if it comes to the husband or the wife, in the evidence, they have not been able to show that the wife has left the matrimonial home.
No, but the
Evidence
finding,
of the husband and evidence of the wife conjointly read together along with cross-examination does not prove that the wife has left the matrimonial home of her own.
lordship, the pleaded case of the husband is that she has left the matrimonial house, lordship. And the husband or his parents never went with the present appellant, lordship, in a railway, through rail up to Madhubani railway station, lordship. So this DW3, lordship, has clearly deposed that it is the mother or father of the wife of the appellant, lordship, who came to Guwahati.
Which place the parents of the daughter had to. Yes.
Lordship, at the time of negotiation, that is settling the marriage, the present appellant said and her parents disclosed before the boy's family lordship that she is a graduate. After marriage lordship, the husband come to know that even she is not matriculate, even she does not know how to write ABCD. And thereafter lordship, the father-in-law of the present appellant, that is the husband father, he has started to teach ABCD to the to that girl lordship, which has been exhibited before the trial court as exhibit number 9 to 12. And in the cross, she has admitted that this ABC, it was taught my father-in-law to me, lordship. In the cross-examination, how she has belied lordship, lordship may be pleased to take up the cross-examination of PW1 in FC civil case number 311. Very important thing, lordship, how she entire family has cheated the boy.
Mr. Roy,
Yes.
nobody would know the meaning of caveat emptor before more than you.
Lordship, here main thing is whether after 12 years living separately, it is possible to live together, lordship.
So why not?
It cannot know, lordship. Your lordship will recollect that Dastane versus Dastane, 1975 SC, where the husband given a note daily that you have to wear this type of color sari, this type of blouse, this type of hairpin, and ultimately the both the courts below lordship dismissed the divorce petition filed by the wife. Then the matter went to the apex court. The apex court held that yes, it is a mental and physical cruelty. How the husband will direct the wife to you wear this color sari, this blouse, this color hairpin, this color surma. So ultimately divorce was I have come with that judgment.
Nobody came to my what you call to my rescue when I am dictated these terms in my own home.
Your
I
lordship
can't wear anything
lordship
which-
is very
which-
lucky.
which madam does not approve. I can't wear.
Your lordship has enough tolerance power. That's why.
Huh?
Patience is the pillar of success. One is the master of the success, he is the master of all.
PW?
PW lordship 1. That is why. That is why. Ragini Jha.
Cross examination.
Yes. Cross examination dated 7/4/17.
No, I can be pulled up. Okay, no worries. I will speak the incentive for the student since 1564 separately from me. It's been responded by what? Since you should be there. Yes.
Yes. I have instituted the instance case for restitution of conjugal rights. Since 15/6/11, I am staying separately from my husband. Respondent, I got married with the respondent on 18/2/11. We got married at Madhubani, Bihar. And after my marriage, I came down to my matrimonial home at Guwahati. I am a graduate in Hindi. This is important, Lords. I am a graduate in Hindi medium, having honors in home science. I was having the following subjects during my gradation. Mathly consisting of 50 marks, Hindi of 50 marks, music of 100 marks, and home science consisting of 400 marks. During 1 year, I was having 3 papers in home science, and in the second year, 4 papers and 3 papers during third year. I do not remember the name of the papers on home science, which I did during my graduation. I passed graduation in the year 2013. Lordship will be pleased to peruse that within 2 years, she has completed her graduation after matriculation. I passed matriculation in the year 2004, Lordship. I have not filed any document to show my educational qualification about which I deposed in my examination in chief. After my marriage, while coming to my matrimonial home for the first time, I was accompanied by my brother. It is not a fact that I have deposed falsely that I did graduation. Since I have not filed any document in the instance case to prove the same, I do not know. I do not know read and write English. Later on depose that I know read and write English to some extent. The name of my 2 sisters-in-laws are Bobby and Mamta. Both are married and are staying at their matrimonial home. Prior to my marriage, both my sister-in-law got married. It is not a fact that I deposed falsely that after my marriage, my sister-in-laws were residing at my matrimonial home. As the matrimonial home of my sister-in-laws are situated near to my matrimonial home, therefore, after my marriage, they used to come to my matrimonial home. After my marriage, my elder sister-in-law stayed for about 2 months at my matrimonial house. Further cross, next page, Lordship. Next day cross is Lordship on 12/6/70. Lordship got it? In my marriage, my father gave an amount of rupees 7.5 lakhs, gold ornaments, clothing, necessary furniture, TV, refrigerator, cooler, etc. in dowry. I have written in my original petition as well as in my examination in chief that the respondent demanded the aforesaid articles in consideration of marriage, that I have not submitted the relevant sale deed, cash memo, and income tax return to show that my father, while giving me in marriage, had to sell his landed property to arrange all the aforesaid dowry articles. It is not a fact that I could not submit any aforesaid relevant document. Therefore, it suggests that I deposed falsely. Falsely that my father, while giving me in marriage, had to sell his landed property to arrange all the aforesaid dowry articles, or my father gave the aforesaid articles in my marriage. It is not a fact that my father did not give any articles in dowry. By my father gave all necessary articles in my marriage. I have stated as well as in my examination in chief that the respondent used to torture me as I brought dowry in cash and gold. It is a fact that the respondent left me as I brought dowry in the form of cash and gold. The respondent inflicted torture on me by getting instigated by his family members. I have not instituted any criminal case against the in-laws while staying at Guwahati. Though the respondent did not demand any dowry from my father, but my mother-in-law and mother-in-law demanded the same from my father. It is not a fact that my mother on 15/6/2011 herself came to Madhubani to take me to my parental home. It is not a fact that I willing went to my parental home. It is not a fact that I instituted the incident as my counter plea against the divorce petition being filed by the respondent. I instituted a complaint case against the respondent in my laws under section 498A, A, IPC Exhibit A, as the certified copy of the aforesaid complaint petition. I have stated in the aforesaid complaint case that the respondent demanded rupees 10,50,000 as dowry. In the instant case, I have stated that the respondent demanded 7,50,000. Earlier it was 10,50,000 as dowry. Both the aforesaid amounts are correct. It is not a fact that as both the aforesaid amount differ, therefore I depose falsely regarding the aforesaid demand of dowry made by the respondent. Earlier she has deposed that the husband never demanded, if her mother-in-law demanded. I depose falsely regarding the aforesaid demand of the dowry made by the respondent. In the aforesaid complaint petition Exhibit A, I have stated that my in-laws took me to Madhubani railway station and asked me to come back again unless their dowry of demand is fulfilled. In the instant case, I have stated that my in-laws took me to Madhubani railway station and left me there alone, and thereafter I called my father. It is not a fact that I deposed falsely in the instant case regarding the aforesaid facts. The aforesaid criminal case being filed by me at Madhubani has been revived by filing an application by me on 21/1/15 for revival of the same. Exhibit B is the said revival application, wherein Exhibit B1 is my signature. It is not a fact that I revived the aforesaid case with an intention to mentally harass the respondent and his family members. I also instituted an FIR against the respondent and his family members at Guwahati under section 498A IPC in the said FIR, where Exhibit C1 is my signature. In the aforesaid Exhibit C, I have stated that the respondent and his family members started inhuman torture on me, as my father did not give any dowry during my marriage. The statements made in the FIR Exhibit C that several times my husband, my father and mother-in-law and my sister tried to kill me to clear the way, but luckily I had a narrow escape. I tried to bear all tortures, but now it is enough. Are false statements. It is a fact that the respondent wanted an educated and modern wife. It is not a fact that I never used to do daily household works or used to misbehave with the respondent and his family members. I have not filed any petition to get back all the articles given my father in my marriage. All the gold ornaments given in the marriage are in the possession of the mother-in-law. It is not a fact that while staying at my matrimonial home, I never used to eat food all along with the respondent, or used to sleep late at night, or used to wake up late in the morning. It is not a fact that my father-in-law tried to make me learn English. It is not a fact that my father-in-law tried to make me learn English by making me to write English in any notebook. It is not a fact that I deposed falsely. Lordship, may be pleased to peruse the trial court's record. Exhibits 9 to 12 are the exhibits, Lordship, by which the present appellant, that is the wife, used to learn ABCD, Lordship. And in the WS, Lordship, she has stated that she is matriculate. Even she did not produce, she failed to produce any matriculation certificate. In the cross, Lordship, which I have already placed, she deposed that she is a graduate, Lordship, but no documentary evidence has been filed or exhibited, Lordship. So, and the Lordship, here the pertinent question to be decided by your Lordship is this: whether there was a mental and physical cruelty by the wife, Lordship, committed upon the husband, and whether the learned trial court has granted the divorce decree rightly or not. That is the main issue only, Lordship. Now, I'd like to place before your Lordship the judgment passed by the learned. It is very nicely written judgment by the family court lords. Each and every fact has been considered. One thing, Lordship, before. Lordship, factual parts already both of us have placed before your Lordship. Just I will place before your Lordship, maybe come to page 110, which is the issue-wise discussion. Page 110. Para 14. According to the petitioner, the respondent filed false case against him and his parents, and this constitute cruelty against him, for which he is entitled to get a decree of divorce. The respondent has also withdrawn herself from cohabitation. The respondent had left her matrimonial home on 15/6/11, and since then she has been residing with her parents in Madhubani district, Bihar. Since 15/6/12, there has been no cohabitation. As such, withdrawal of the respondent from the cohabitation amounts to mental and physical cruelty. The petitioner and his parents had tried their best to bring the respondent to the matrimonial home, but the respondent refused to come back. The petitioner, as PW1, has adduced evidence in conformity to the petition of the divorce. Both PW1 and 2, the father of the petitioner, have deposed that on 15/6/11, the respondent left her matrimonial home, and despite repeated requests, she did not return back. Thereafter, she filed criminal case against them by making false allegations. The petitioner has exhibited Exhibit 1, the certified copy of the complaint petition filed by the respondent, which has been numbered as complaint case number so in the court of the learned. CGM Madhubani Exhibit 4 is the certified copy of the FIR lodged by the respondent with the officer in charge. All women PS Guwahati again. One thing, your lordship, me pleased to know. At that time, the appellant, present appellant, she was residing in Madhubani. She lodged a complaint case in the court of the learned, CGM Madhubani district lordship, alleging that she has been threatened, cruelty has been committed, 498 sections were imposed lordship, and this fact she has hid in her WS lordship, filed before the family court. And lordship, when she was not residing with me since 2011, lordship, and she has left to her parental house, how I committed physical torture or mental torture, lordship, and that I leave to your lordship. Para 16, that the respondent alleged that the petitioner named her only for dowry and always used to demand money and material aid dowry from the parents and respondent. The respondent examined himself as the respondent examined herself as DW1, her father Lallan Kumar Jha as DW2, and her village uncle Shravan Kumar Jha. He is the DW3 in support of the contention. The petitioner pleaded that the respondent filed a case against him, his parents and sister under section 323, 304, 379, 498 IPC, and filing of such false case against him, his family members, amounts to cruelty. There is clear evidence of the petitioner that the respondent filed 2 criminal cases against him and his family members, alleging torture upon her in demand of the dowry. Exhibit 1 is the certified copy of the complaint petition by the respondent on 10/8/11. Exhibit 4 is the certified copy of the FIR dated 8/4/13, filed by the respondent against the petitioner and his family members regarding demands of the dowry and attempts to kill her by petitioner, his parents and his sister. All sisters are married, lordship. Para 17. DW1, the respondent wife has adduced evidence in support of her contention in the written in the WS. She has adduced evidence that she was tortured by the petitioner and his family members in demand of dowry. In cross-examination, she has stated that in the complaint case, Exhibit 1 being filed by her against the petitioner, she has stated that the petitioner demanded rupees 7,50,000, and the aforesaid case, she have stated that he demanded 10,50,000, and both the statements are correct in her FIR Exhibit 4 and also in the complaint exhibit. She has stated that the petitioner and his parents tried to kill her, which is true. She had not proved any document in support of her evidence stating that the petitioner demanded dowry from her. She denied that she deposed falsely that the petitioner and his parents tried to kill her. She denied that she has caused any mental agony to the petitioner by lodging any FIR or complaint case against him. After lodging FIR against the petitioner and his parents, she came to know that her mother-in-law and father-in-law were taken into police custody. After knowing about the same, she did not withdraw the FIR against them. She want to still lead conjugal life with the petitioner in spite of being inflicted with mental and physical torture by him. Para 18, apart from the oral evidence of the witnesses for the response, there is documentary evidences available on record to prove the fact of the demand of dowry from the respondent. DW2, the father of the respondent revealed in cross-examination that the petitioner demanded dowry from him prior to the marriage of the daughter with him and subsequently also. He has stated, lordship, the wife is saying, or in WS and in the cross, that after marriage, after 2-3 months of the marriage, the husband wanted to demand dowry. Here, her own father in cross-examination deposed that his husband demanded dowry before solemnization of the marriage, lordship.
And then subsequently.
Subsequently. He denied, he deposed falsely that he has stated in the examination in chief on affidavit the petitioner demanded dowry from him prior to his marriage with her daughter. He stated in his examination chief affidavit that he gifted his daughter gold ornaments, furniture, and household articles and cash amount of rupees 7,50,000. He as a dowry did not give anything to the petitioner at the time of their marriage. Nothing was given. So entire case filed by the appellant is based on falsehood. Para 19. It appears though there is allegations of giving dowry to petitioner at the time marriage, but in reality at the time of marriage he was not given dowry as revealed by DW2, father of the respondent, in his cross-examination. Para 20. DW3, the village uncle of both respondent and the petitioner, also revealed in cross-examination that the petitioner did not demand any dowry from the respondent. Thus, the respondent has not been able to adduce sufficient evidence to establish the fact that the petitioner tortured her demanding dowry. That there is no convincing evidence to establish the facting of the dowry demand, therefore, filing of cases, making serious allegation of demand of dowry, and committing criminal activities against the petitioner, his family members, amounts to mental cruelty upon the petitioner. However, there is an inconsistency between the statement in pleading and in this case, her FIR before the police at Bihar as to the facts and circumstances in Jarusi had been left at railway station by the parents of the petitioner. It appears from Exhibit 1 that the respondent in her complaint stated that on 15/6/11, the father and mother of the petitioner brought her from Assam to Madhumini station and told her to go to her father's house and not to return back until and unless her father gives all the goods as promised. Then she called upon her father to Madhubani station and went her to parental house with him. Para 23, in the present case, the allegations of the respondent that as he was compelled to live in his parental home by the petitioner and his parents took her to Madhubani, Bihar on the pretext that they were also going to their village at Bihar and taking advantage of the trip to Bihar so she can meet her parents. On 20th/6/21, on reaching Madhubani railway station, her lodge asked her to sit on a bench in the station, and on the pretext of the bringing food, they left one by one. When after waiting for several hours, her husband and in-laws did not return back, having no alternative, she was compelled to call her parent and had to go the parental home. Para 24, there were two versions of the situation under which the respondent was allegedly compelled to to leave her matrimonial home. While in her pleading as well as in her evidence in the instance case, the respondent alleged that the petitioner and his parents took her to Madhubani station and secretly left the station, leaving her alone in the station. But in the complaint, Exhibit 1, she has stated that she was brought by her father-in-law and mother-in-law to the Madhubani railway station and asked her not to return without the demanded articles. As per the statement of respondent in her complaint, the petitioner was not present at Madhubani station. Such inconsistency in her statement in the pleading and the complaint shakes the veracity of her testimony that the petitioner and his parents left her in Madhubani railway station. Para 25. In this regard, I have also gone through the evidence of the PW3 who has deposed in his cross-examination that the mother-in-law and father-in-law of the respondent took her to their village Madhubani from Guwahati. After coming to petitioner's home at Madhubani, respondent was taken to her parents' house by father for a few days to perform certain rituals which were to be done after the marriage. During the stay of the respondents at her marriage house, demand of dowry arose by the petitioner and his parents, and they told the respondent if their demand was not fulfilled, they would not take her back with them to house. After the said incident, the respondent was not taken back to matrimonial home. DW3 has stated a different story as to how and when the respondent went to her parental house and started residing there. According to him, the respondent was taken to her by her father from the house of the petitioner in his native village to perform certain rituals. Thus, there are contradictory evidences adduced by the respondent with regard to her stay in her parental home. However, there is nothing on record that before filing of the complaint case in Bihar against the petitioner and his family members, the respondent had never tried to return back to her matrimonial house. Para 6. It is found from the evidences on record that the respondent has made a serious allegations of attempt to commit her murder by the petitioner, his parents and sister. It is indeed very surprising that despite the fact that she was tortured to such an extent, she is still ready to live with the petitioner and restore cohabitation. On 10/8/11, the first party case against the petitioner and his family members, thereafter again in 8/4/13, an FIR was lodged against the petitioner and his parents for what they had to obtain bail from court. The respondent initially filed criminal cases against the petitioner and his family members alleging demand of dowry and physical torture upon her. Only after filing of the divorce case, she had filed petition for restitution of the conjugal. Hence, there is doubt as to true intention of the respondent with regard to willingness to restore cohabitation with the petitioner. The respondent further contended that the petitioner wanted an education and modern life. If the petitioner wanted to marry an educated and modern life, then definitely the question arises as to why the petitioner, despite knowing that the respondent was a matriculate, married her. It is also appears from the evidence of record that PW1, the petitioner, and PW2, father of the petitioner, had deposed in their evidence that after marriage, every day the respondent used to pretend to read English daily newspaper Assam Tribune, but when the petitioner asked about the headlines news, she could not say anything, and then only they came to know that the respondent was an illiterate person. PW2 has deposed that he tried to make the petitioner understand an event through the respondent is illiteracy could be taught to learn English, and being the guardian, he undertook the responsibility to teach her to save the marriage of his son. PW2 has exhibited 4 copies wherein the respondent practices read and write English as exhibit 9 to 12. You see, writing of ABCD. Para 23. The respondent has admitted in cross-examination that exhibit 9 to 12 series are written by her. She has admitted that her father-in-law tried to teach her in English. It is very difficult to believe that a person who has passed out high school living certificate does not have knowledge of alphabet of English language. But here in this case, the respondent was taught alphabet of English language by PW2, her father-in-law, as evident from exhibit 9 to 12. Therefore, it is difficult to believe that the respondent was matriculate at the time of her marriage. All these facts lead this court to draw the inference that the petitioner know about the actual educational qualification of the respondent he would have never married her. Where a person who wants his wife to be educated would definitely give consent to marry an educated girl and not otherwise. Hence, it appears that there is consistency in the evidence of the petitioner, and prior to marriage, the parents of the respondent lied about the educational qualification of the respondent. 29 para. It is also found from the evidence of the respondent that she revealed in cross-examination that in the year she was graduated, but according to her, in the year 2011, at the time of marriage, she was matriculate only, and thus it is not believable that within a period of 2 years, she has obtained graduation. The statement of DW1, the respondent, with regard to the education qualification is not consistent. According to the para 30, according to the petitioner, the respondent is mentally unstable person. However, there is no evidence. Then 31, that since 15/6/21, both parties have not living separate, have been living separately for more than 10 years. Now it is 12 years a lot. The marriage between the parties have been irretrievably broken down, and there is hardly any scope of their reunion. In so and so, Supreme Court citation is there regarding the breakage, marriage lordship. It may fairly be conduced that conducted that the matrimonial bond is beyond repair. The marriage becomes a fiction, though supported by a legal tie. By refusing to sever that tie, the law in such cases does not serve the sanctity of the marriage. On the contrary, it shows a scant regard for the feelings and emotions of the parties.
Mr. Roy,
Yes.
I am sending you my time. Read the first line of this.
First line.
Yes, Hendrik Frederick,
Yeah.
correct.
May I read?
Yes, yes.
The youngest person to be awarded a PhD is the German child prodigy John Henrik Friedrich Karl Wright, born on July 18, better known simply as Karl Witte, who received his doctorate from the University of Gießen, Germany, on tenure at the age of 13. No, sir, exceptions are there.
No, what I'm saying is that in 2 years degree, because here a child at 13 years of age got a PhD.
No, there are many such examples, Lordship. But degree, it is to be proved, Lordship. She never filed or exhibited any educational testimonials before the learned trial court. And if a person, Lordship, be pleased to consider that if the husband or his parents have intention to driven out the present appellant, Lordship, why the father-in-law have started teaching English alphabets to her daughter-in-law, Your Honor, Lordship? So we had
Is the education qualification is it really a requirement for the marriage?
no, Lordship.
Then
It is the false information furnished by the parents of the present appellant to the husband's family, Lordship, and which causes serious mental and physical agony, Lordship. Physical agony, Lordship. A person,
so
the
you have married her because she is the graduate,
yes, Lordship, because
just because of that. Just
Yes,
because
Lordship,
of her
the-
qualification or something.
the appellant's family disclosed to the family of the husband, Lordship, being graduate. I have placed before your Lordship the cross-examination of the appellant, that is the wife, Lordship, where she deposed that she has done graduation in home science.
That's why you have married.
Yes.
Otherwise, you would not.
Yes, certainly, no, I would have not married. Certainly, I would have not married. Why I should marry an illiterate lady, Lordship? Why? There may be some equilibrium of the status, Lordship. There are many such cases where, Lordship, the educational qualification was suppressed.
But see the literacy rate in the country.
Now that, so the husband, she will get an illiterate husband,
No,
not literate or
It will not-
semi-illiterate.
it will not be an equilibrium. It has to, it will be other way around.
Lordship, that is not the qualification.
There
of-
should be a balance
If they have
in the
disclosed,
country.
when the Lordship, the appellant's family have disclosed that she is illiterate lady, then the matter would have been, if they have disclosed that she is only matric, that would have been a different thing. But while just for giving false information, Lordship, the marriage was solemnized, which is a Lordship fraudulent act on the part of the family of the appellant, Lordship, fraudulent act.
These are civil liabilities, caveat emptor will apply.
I am having such decisions, Lordship. I have come with the bunch of Supreme Court decisions on this line. And Lordship, rightly the divorce was granted. Because since last 12 years, they are living just like a puppet. Lordship, be pleased to, without any cohabitation. And even if the learned family court would have granted the decree for the restoration of conjugal, like actually there would have been any actual love and affection and cohabitation between the parties, never, Lordship.
Why not?
So it is the duty of the court, Lordship, to that the parties should not be allowed to live like a puppet. They must live as a real husband and wife, having love and affection, respect against each other,
No,
Lordship.
there is a case of a celebrity politician in Bihar,
Hmm.
where after 30 years he married the women who. whose
Anchor,
child-
TV anchor.
No, where a child filed a paternity suit, and the
Uh-huh.
late politician, he had to marry.
And
the lady.
the Tiwari case is
No,
there.
I'm not saying. the
ND
name.
Tiwari.
I'm not saying. the
Yes,
name.
ND Tiwari.
But-
There are many other. Ravi Shankar, Lordship, the famous musician of the world. He married his disciple who was only 21 years old.
No.
That your Lordship is aware, whereas Ravi Shankar was 75. So that there was a true love and affection, Lordship.
No, but in the
There
first
wa-
case, which I'm saying, there was no true love and affection. But
There,
he
there
married-
he was a professor
No.
in a college.
no,
In
the first
Bihar case, Lordship, he was a
No,
professor.
whatever be, but there was no
And
prohibition
a girl student, they
No,
were
but
in
there
love
was-
and he married.
But there was no prohibition for 30 years. After that, when the paternity suit came, then he married.
Married, that is, ND Tiwari case is that the
what I'm
earlier
saying.
CM of
There was
Uttar
no,
Pradesh.
there was no
Uttar Pradesh.
prohibition.
So there was a DNA test and
No.
in
In this case, there is no prohibition for 11 years. In that case, there was no cohabitation for 30 years.
Not 30 years, Lordship, but the boy was born when there was cohabitation, Lordship. I know that case, N.D. Tiwari. So, Lordship, I have come with a bunch of the citations, Lordship. I have marked the paras also. I am submitting one of the copies, Lordship, of the informed judgment. Only one judgment I would like to place before your Lordship. Only gist. Because granting divorce or refusing divorce, the apex court has fixed some criteria, Lords. Itu the person. Owns me like this is. I like. No. Sorry, my lord, I could not highlight it. No, just one judgment regarding mental cruelty, Lordship. Citation is Lordship 2006, 13 SCC 272. Relevant para is Lordship 6-7. I'll submit the, I am having the Xerox copy. Para 7. The word cruelty and the kind or degree of cruelty necessary which may amount to a matrimonial offense has not been defined in the Act. What is cruel treatment is to a large extent a question of fact or mixed question of law and fact, and no dogmatic answer can be given to the variety of the problem that arise before the court in this kind of cases. The law has no standard by which to measure the nature and degree of the cruel treatment that has to be a standard by which measure the nature and degree of the cruel treatment that may be satisfy the test. It may consist of a display of the temperament, emotion, or perversion, whereby one gives vent to his or her feelings without intending to injure the other, if not consistent of direct action against the other, but maybe misconduct indirectly affecting the other spouse, even though it is not aimed at that. It is necessary to weigh all the incidents and quarrels between the parties, keeping in view of the impact of the personality and the conduct of one spouse from the mind of the other. Cruelty may be referred from the facts and matrimonial relations of the parties and interaction in their daily life disclosed by the evidence and inference on the said point can only be drawn after all the facts have been taken into consideration. When there is proof of a deliberate course of conduct on the part of one intend to hurt and humiliate the other spouses, such a conduct is persistent. Cruelty can easily be inferred. Neither actual nor presumed intention to hurt the other spouse is a necessary element in cruelty. So, Lordship, my humble submission in this, Lordship, the parties are living almost 12 years separately, no cohabitation, nothing, there no speaking terms, Lordship. So if the Lordship rightly, the judgment was passed by the London Trial Court, decreeing the dissolving the marriage by divorce, Lordship. And so, Lordship, there is nothing to be interfered, Lordship, and Lordship may be pleased to consider. Series of cases were filed by the wife, not only against the husband, mother-in-law, father-in-law, sister-in-law, though the sister-in-law.
Two cases. Only two cases.
No, one case also she has filed, later she has withdrawn.
Yes,
Let us
file
see.
one, my lord,
Ah.
and one FIR.
FIR. One case in
and
Bihar,
one FIR.
One case
CJM
and one
court,
FIR.
Bihar, they there 498 case, Lordship. And one she has also filed, she has withdrawn. Ah. So, Lordship, there is
That
no
case is still pending.
revival is pending. Revival is pending. Huh?
I think so.
Revival is pending. So, Lordship, this is there is nothing to be interfered, Lordship, because Lordship may be pleased to consider when my parents were arrested by the police, and Lordship, ultimately they released me in the next morning, then I obtained anticipatory bail, Lordship. So no husband will tolerate such type of high-handedness activities on the part of the wife, Lordship. Tu nahi to aur sahi. That hurt, certainly the husband will follow that. Certainly every husband will follow.
Because you have demanded dowry, that's why a case has.
No,
been
Lordship,
filed.
her father deposed in cross that the petitioner, the husband never demanded any dowry. Whatever it was given before marriage. Lordship may please to consider this Maithil Brahmins, Jha. Whenever your Lordship will find a title Jha, means he or she is Maithil Brahmin. In Maithil Brahmin, in Bihar, marriage system is entirely different, Lordship. That you will, Lordship will go to in Mullah, Hindu law, Hindu law. There, how they celebrate, solemnize their marriage, there a mela is held. There all the boys who wants to marry, they will sit in a line by wearing mala, garland, Lordship. That is called, your Lordship, Manigachi. There is a very big mangoes garden, Lordship, in district Madhubani, just by the side of the NH 57, Lordship. Because I am also originally belong to Bihar. My house is still, my parental house is still in district Muzaffarpur. And Madhubani is only 35 kilometers from Muzaffarpur, Lordship. I always visit Muzaffarpur by car and cross across the Madhubani district. So there is that mango trees is called Manigachi, that your Lordship will find in the net. Just my Manigachi marriage, just your Lordship, every details will come. There, Lordship, the girl's father or brother comes and select a boy. And from there, the boy will go to the girl's house alone. Marriage will be solemnized. There will be no parents from the side of the bridegroom, Lordship, and no barati, nothing else. Marriage will be solemnized. The boy will remain in the girl's house for 7 days. Thereafter, he will come with his wife to his own native place, and no dowry is given in that type of system of marriage. It's just like a Gandharva Vivah. Gandharva marriage, your Lordship, had gone through that Mullah Hindu law or principles of the Hindu jurisprudence written by Justice, P.N. Sen, which is generally taught in the LLM class. So, Lordship, here in the Maithil Brahmin, they are very highly literate person, Maithil Brahmins here, Lordship. The first governor of the India, of the RBI was L.N. Jha. First governor, who is called the father of the banking system of India, Lordship. Or L.K. Jha. He was the first governor of the RBI. So these Maithil Brahmin, they are very highly educated persons, lordship, well-to-do, your lordship, and that's why. And here in Assam also, your lordship will observe, when a Brahman marries, given in marriage, lordship, the Bharatis or the invitees will be very less. But in case of the other caste, the numbers will be much more. Lordship, in our marriage, lordship, not less than 400 to 500 Bharatis will go, invitees, along with the bridegroom lordship. And with
acceptance of that can't be taken because your groom has not given his particular educational qualification.
lordship,
The husband is not giving his own educational qualification.
given BSc, BCom, he BCom from Guwahati Commerce College. My learned friend, and while submitting arguments, he has submitted that he is BCom. That is not disputed, yes.
BCom is not highly educated.
A graduate,
BCom is not highly educated.
so I am submitting the judgments on the cruelty, lordship, and the other, of the almost all apex court judgments. Kotak Bisa. Already I have.
My lord,
Yes.
my lord. If lordship will go very thoroughly from the paragraph 14, the discussion to up to my lord paragraph 33, lordship will see that this is a one-sided judgment. The court below has gone one side. They had court below has not discussed about the petition, the divorce petition, what there is. Only discussed what the complaint petition is there, what is there in the FIR, what is said by the DW3, what said the father of the wife, my DW2, has not said anything. What about in the pleading, in the plea? It is a one-sided, my lord, first thing. Second thing, so for educational qualification, they know what is the educational qualification of the wife. In the evidence, clearly said, he clearly said that I have seen the certificate. Has not said that in the certificate she is BSc, she is matriculate, she is something 8 up to or 9. See, he carefully said, I have seen the certificate. Evidence there is, husband said that I have seen before marriage, I have seen this, that they know that her qualification before marriage. And that after that, she in evidence see that they have a good relationship for 2 months. Very good relationship. Before marriage, she found her very good. And 2 months, they were very good relationship. It is a frame case. It is also not denied that they have not taken in the name of gift or in the name of dowry, but they have taken the money, 7,50,000. It is not denied. Yes, they have given prior to marriage as a gift. Yes, is given. They have framed the case. They took 7,50,000. They know that she is illiterate, so they given tuition to the wife to prove that this alphabet is a frame to prove that she is illiterate. If the father-in-law loves her daughter-in-law so much, how can the father throw the wife at Madhubani rail station? How can he depose like that? If truly he loves his daughter-in-law, he will make his daughter-in-law appropriate to her son. In 1 year, she will be, if he try truly, she will fit for her husband. She will learn English, she will learn to dress, she will do everything. What is impossible? It is not impossible. If really this was done just to frame a case, my lord. They know that she is illiterate. They took the money, they married, they 2 months, they live very nicely. Then they thrown out. That she will go, then they will marry another and will take again. This is the true fact, and that which has been not reflected in the argument. Judgment is one-sided. Only if Lord will go thoroughly, Lordship will find that it is one-sided. It has consulted the things light in the complaint petition and FIR, that cruelty. This is my submission.
Right. But this is P. Burman, and counsel for the appellant. in both the appeals. First, also heard Mr. S.P. Roy, learned counsel for the respondents is both the appeal. This appeal, these two appeals arise out of common judgment and order dated 11/2/2022, passed by the learned principal judge, Family Court -Roman 3, Kamrup Metro Guwahati, in FC within bracket civil bracket close case number 107/2013, as well as FC civil case number 311 of 2013. Full stop. Next para. The proceedings of FC civil case number 107 of 2013 arises out of an application filed under section 13 of the Hindu Marriage Act 1955 by the respondent husband seeking decree of divorce against the appellant wife. Full stop. The proceedings of FC within bracket civil case number 107 of 2013 arises out of an application filed by the appellant wife under section 9 of the Hindu Marriage Act against the respondent husband seeking restoration of conjugal rights. Full stop. Next para the learned Family Court by the common judgment dated 11/2/2022 allowed the decree of divorce in favor of the respondent husband in FC civil case number 107 of 2013, and insofar as the application for restitution of rights filed by the appellant petitioner, by the appellant wife, being FC civil case number 107 of 2013 is concerned, the said application was dismissed. Full stop. Next para. In brief, the case of the respondent husband in FC civil case number 107 of 2013 is that here the appellant were married on 18/2/2011 in Madhubani district in Bihar, as per the Hindu rites and rituals. And thereafter they came to Guwahati on 15/3/2011 and started residing as husband and wife. It is projected that after a month of their stay, there were matrimonial discord between the parties. The details of the matrimonial dispute narrated in the divorce petition is not been referred to. It would suffice to mention that the grievance of the petitioner is that of the respondent husband was that before the marriage, the appellant wife was projected to be a graduate in arts from Bihar University, which was later on discovered that she was only a matriculate, right?
She is not also matriculate.
She was not also, no, she was not matriculate.
In her WSC stated she is matriculate.
And it is alleged that the respondent husband was cheated as he got a illiterate and mentally unsound woman as his wife. Stop. It is projected that on 15/6/2011, after 3 months of marriage, after 3 months of staying at Guwahati, the appellant wife left the house of the respondent husband and went to her parental home at Madhubani district in Bihar, along with all the gold ornaments she got during her marriage. To stop. It is alleged that the respondent tried to settle the matter amicably for a demand of rupees 5 lakh. Rupees 5 lakh was made by the appellant wife. No, by the in-laws of the respondent husband. Thereafter, next paragraph, thereafter, the appellant wife lodged a complaint case against the respondent husband and his father, which was registered as complaint case number 1080 of 2011. Before the court of the Chief Judicial Magistrate Madhubani, under section 323/304 /379 /498 capital A /34 IPC. Alleging, inter alia, that after the appellant wife came to Guwahati on 2011, she was being harassed by demanding car, TV, washing machine, fridge. And the appellant wife was threatened of being burnt by pouring petrol on her body. Accordingly, on the ground that the appellant wife had caused mental and physical cruelty to the respondent husband and his family members. The divorce petition was finally prepared to annul the marriage of the respondent and the husband as respondent and the appellant as husband and wife respectively. Next paragraph. The respondent, the appellant wife contested the case by filing a written statement. Denying that she had ever created any nuisance or neglected the matrimonial duties. All the allegations made in the divorce petition was denied. So it was stated that the petitioner had, the appellant had completed education up to class 10 at Bihar. A fact known to the respondent husband, and that she had not misled the respondent about her educational qualification. It was denied that the appellant was mentally unsound. First of all, it is stated in the written statement to the effect that the respondent husband never wanted to marry he wanted to marry a modern town girl, for which he was not happy with the appellant, and that the respondent had married the appellant only for dowry, and used to demand money and materials as dowry from the parents of the appellant. It is alleged that on 26/2011, on the pretext that the father of that the parents of the respondents were going to Bihar, took the appellant with them to Bihar, and on reaching Madhubani railway station, She was made to sit in the bench in the station. And one by one, the parents of the respondent left her. And when they did not return after several hours, the appellant called her parents who had taken her home. So accordingly, it is denied that the appellant had left the matrimonial home on her own. So it is alleged that the parents of the father of the appellant had provided her with gold ornaments and given a cash amount of rupees 7.50 lakh to the respondent by selling his land. It was denied that the appellant or her family members made any threatening call to the petitioner, to the respondents, to the respondent. This one. It's denied that the respondent was ever informed that she was that the appellant was a graduate. And it is also projected that the allegations of the appellant suffering from mental disorder or psychophresia is only a ground manufactured for obtaining a degree of divorce. It is also projected that after the appellant had filed a complaint case, after 9 days, the respondent retaliated by filing a complaint case registered as case number 2347, superscript C, public 2011. Superscript C, short, small c. Under section 417, public 420, public 379 of the 506 IPC, before the Court of Chief Judicial Magistrate, Kamrup Metro, Guwahati. First, it is projected that when the appellant and her parents came to Guwahati on 3/4/2013, the respondent called police personnel from Hollywood police station to arrest them. Nonetheless, the stand of the appellant is that despite everything what has happened, she wants to resume cohabitation and conjugal life with the respondent, expressing that she was hopeful of she was hopeful that the respondent and his parents would understand and realize their fault. Full stop. Next paragraph. In the application filed under Section 9 of the Hindu Marriage Act, which was registered as FC Civil number 311 of 2015, the appellant by reiterating the stand taken in the written statement in FC Civil case number 107 of 2013, has taken a stand that the petitioner, being a Hindu lady, divorce in her society is a rarest phenomenon, and therefore he has expressed that she will try her best to adjust with the respondent and the family, and also express surprise on receiving the petition for divorce from the respondent, and has taken a stand that she intends to give one more chance to the to save their married life, and desires cohabitation and continuance of conjugal life with the respondent. Next paragraph. Suffice to mention that the respondent, in his written objection against the petition for restoration of the conjugal rights, has reiterated the stand taken in the divorce petition, and has prayed for dismissal of the said application. Next paragraph. The learned counsel for the appellant has submitted that the issues were decided by the learned court below without any appropriate discussion. It is submitted that that on a conjoint reading of the that on a reading of the impugned judgment, it will be apparent that the said judgment reflects one-sided point of view of the respondent and had not discussed the stand as well as evidence of the appellant side. It is specifically submitted that the learned trial court did not make any endeavor to find out or to determine as to whether or not that the appellant had left the matrimonial home. submitted that the parents of the respondent took the appellant to Madhubani railway station and left her there. That's right. It is submitted that an evidence was created to show as if the applicant was illiterate by making her write English alphabets in a copybook, which was then used as an evidence to project as if the applicant was an illiterate lady. So it is submitted that it has been admitted by the respondent husband in his written statement that he saw the certificate where he said that
My lord,
he saw the certificate. Where did he say that?
in the cross, my lord.
So it is submitted that the respondent husband in his cross examination in the proceedings of FC civil case number
107.
107 or 2000.
Respondent showed all her educational certificate.
107 or 2013,
14/6/2017 the cross.
that he has seen the certificates of the appellant before marriage. Accordingly, it is submitted that was a false and manufactured case made of seeking divorce that she had represented herself to be a graduate. Is submitted by the London Council for the appellate. That not only a demand of ₹5 lakh was made by the respondent for the said marriage. But later on also, when after she came to Guwahati, she was being harassed with demands of car, TV, washing machine, fridge, etc. It is submitted that at no point of time the appellant did not have a brother by the name of Akhilesh Jha, AKHILESH, Jha. And that her brother never resided in the matrimonial home. Be that as it may, by referring to the stand taken in the memo appeal, the London Council for the petitioner has submitted that despite being driven out from the matrimonial home or demand of dowry or taking of cash amount of ₹7.5 lakh as 50 lakh as dowry, And despite suffering from mental and physical cruelty, the appellant still desires restriction of conjugal rights. So accordingly, it is submitted that the impugned common judgment in both the cases is set aside. And allow the application for restitution of conjugal rights. Yes, anything I've left out? No.
My lord,
Anything I've left out?
I think no. No,
Next, madam.
for the honorable court below said that dowry, there is no documentary evidence. But where from she brought documentary evidence regarding dowry, my lord? These things are there, my lord.
It is also submitted that the learned trial court disbelieved the stand of the appellant merely because she could not produce any documentary evidence. So in this regard, it would be very difficult or rather impossible to get a proof of demand of dowry.
Lordship, one thing I will just, the appellant stated that by selling the land of her father, dowry was given. No swell deed was produced. It was very.
Next one. For contract, the current counsel for the respondent has submitted that the genesis of the foundation of the marriage was made on a fraudulent stand of the appellant and her family members to project the appellant as a graduate when she was not. So it is submitted that if the appellant, and sorry, if the respondent had known earlier that the appellant was not a graduate, he would not have solemnized the marriage. It is submitted that it is not in dispute that in connection with the complaint case lodged by the appellant, as well as the FIR lodged at Guwahati by the appellant, the parents of the respondent were arrested and detained for a day. It is submitted that when an allegation of attempt to murder and demand of dowry is made, it amounted to mental and physical cruelty. For which it is possible for the respondent to start cohabitation with the appellant. It is submitted that the decree of divorce against the appellant was rightly passed by the learned trial court on the ground that she had not only left the matrimonial home on her own volition, but had also treated the respondent and her parents with cruelty. In support of the submissions that cruelty constitutes a good ground of divorce, the learned counsel for the petitioner has referred to the following following cases. It was citation. So facts have been narrated, and we'll dictate the orders after some time. We may After it is transcribed and released, I think you'll get it not before Monday.
Okay.
If you once you send. So just, although we have halfway dictated, it's a duty to ask you, Mr. Roy, can you take instructions and come back tomorrow morning at 10:30 and tell us whether the respondent is ready and willing to at least have a sitting in the mediation center, the court conducted mediation, if there is any possibility of resuming the conjugal rights.
No, Lordship, there is nothing. No possibility, no remote,
No chance.
no chance.
But still, can you still?
Because Lordship may be pleased to consider, since last 12 years, they are living separately. She is in Bihar, I am at Guwahati.
No, that is still okay. But can you still have telephonic instructions?
I had a discussion with my client yesterday, Lordship. Flatly he refused. And before the family court also, there is a provision for conciliation. For conciliation, it took almost 1 year, but no result.
Because when Ms. Burman is making a submission that the appellant still wants to resume conjugal rights. I believe she
That
has.
is a
instruction,
mere
otherwise she will not-
statement, Lordship. Actually,
I know her well. When she's making a statement, I think she must have got instructions. Otherwise, she'll not make the statement.
Lordship,
That much confidence I have on her.
see, Lordship, actually, she is according to a statement of her husband, Lordship, she never cooks any food for the family. She used to sleep whole night. She remained, she did not sleep. And in the morning she wake up by 11 and 12. The husband used to cook the food. All these things are on the pleadings, Lordship.
At times I also do that. What is wrong in it?
That might be your Lordship hobby, but hobby, I am a very good cook, but after my marriage, I never cook.
Well, one thing is there, they have said that they tried so many times to bring her back, but no explanation how they tried, what attempt has been taken.
If I had no intention, Lordship, why father-in-law we started teaching ABCD to the,
Just to frame the case, my lord,
just to frame the case,
just to frame the case, my lord.
frame the case.
You see, if you read my handwriting, you will gather an impression that I am illiterate. If you read my handwriting.
My handwriting worse than your Lordship. Because at that time there was no cursive writing, nothing. I read up to class 6 in Fancyware Hiralal Joshi school, which was Hindi medium venture school. We used to write with bhatta. Your Lordship know bhatta. That thick chalk without any having point. Rama, Goti, Deha,
Very late in point of time. In fact, about a month back only I came to know that Guruji, you said that Hiralal
Joshi school.
Joshi school. The Hiralal Joshi, or it was Badridas?
Badridas was near Purv Jyoti Press. And Hiralal Joshi School was at Kamla Gali Fancy Bazaar, near municipal market, And Guruji, he used to taught us in Marwari, Rajasthani language. Even he spelled slang language. Gutti gutti ko nahi marno abe salo tane. Iya padaya pata. I can count this Pahara.
I recently only came to know about that, this Badrida school which was there.
Pardon, Lord.
Badrida school which was there in Fancy Bazaar.
Huh.
The Guruji was none other than the father of Advocate Satyajit Sharma,
Yes, related.
father.
He was such a good, nice person.
I was not aware of it, but he was a respectable person and
On the day of Saraswati Puja, he performed Saraswati Puja, Guruji, and they are expired.